My lord, I beg to mention item number, my lord, 51, my lord. Last item, my lord. May be taken up, my lord, as the last item.
Yes.
May be taken up, my lord, because my lord, it's long by in the list, my lord. Subject to lordship convenience, if time permits, my lord. May be taken up. 51.
Matter pertains to?
Family pension, my lord.
Oh. Why is it rule has been issued in this matter?
Your lordship, please to earlier occasion, your lordship heard this matter, my lord.
Then why? But then also, why the rule has been issued? The pension matters, if you issue rule.
Karbi Anglong Autonomous Council.
Okay, inform them.
Yes.
We'll try to finish
Yes,
it up.
Item number 25 to 38, madam. Some further 7 days time may be given, madam. I've taken the concern of the other side.
Why?
It can be on 13, madam.
Hmm?
It can be on 13th, madam. Tuesday.
My lord, 15 would be 15th of June.
13 or 15, madam.
Mr. Gogoi,
Madam.
what I asked you in
Yes.
this matter was, I got the answer.
Lordship has got that.
I searched and got it.
Okay.
The question which I put to you was,
Yes. Whether it has been subsumed after the.
no, not only that. When you issue a particular notification
Lordship,
exempting,
madam.
wouldn't that mean that it has already been subsumed? Can you
Yes.
impose or exempt somebody
Lordship.
if it is not a part of it?
My lord, exemption will have to be, my lord, pursuant to some, my lord, authority given in the act or the rules. Yes.
Therefore, otherwise it is
Imposition of
subsumed.
tax is the, my lord,
The
rule.
moment you exempt
Lordship.
means it is
Otherwise,
otherwise
exemption is-
believed that it has already been taken care of. You see the judgment of the Supreme Court in 2007 or 4.
Lordship.
2007 4 SEC page 3,
Madam.
wherein the Supreme Court says
Lordship.
that you cannot exempt somebody unless you have the authority upon it.
That's the authority, my lord. It will have to be, my lord, from the act or the rules to exempt. Imposition of tax is the rule, my lord. But to exempt it, my lord, again, my lord, it's against the policy. But it will have
No,
to
no,
be
no, no,
some
not on that.
authority.
I'm not on that. There is no quarrel with the proposition that you have exempted.
Lordship. Yeah, the notification is very clear.
Not only you, the central government have exempted. There is no quarrel with that proposition because the fact is admitted.
My lord.
The only question was to see as to whether it was subsumed.
Lordship.
If it is subsumed, only you can exempt.
Lordship.
Otherwise, you have no power to exempt. It will be something like you are doing tomorrow for Bihar. Can you exempt somebody in Bihar that you have liquor out there? No problem will happen. You have the authority. No, you should have the power
My lord.
over the subject matter.
Lordship.
So therefore, you have exempted it. Once you exempt it, means that you have it is already you have the power to levy.
Lordship.
So this is the answer to that.
I will place the detail, my lord. It will be more convenient. Everything will be clarified.
No, the problem arises why if we adjourn a particular matter, it becomes difficult to later on
Yes.
fix it in the list. Because then on 15th you have some other matter,
Lordship.
or 13th you have some other matter.
No, on 12th, my lord. It has been
Those matters are there.
on 15th. In
So the
case.
pressure upon this court is more.
Yes.
When you get hold of the GST council also,
GST. Yes.
Mr. Kyle,
Yeah.
so that he can also address if necessary.
Lordship.
Huh?
I will intimate.
You just intimate him because that is because there are two notifications.
Yeah,
One is the
state-
central government, one is by you.
Yes, sir. Lordship.
And madam, you also, your basic case is for refund. For refund, you have to show that there has been no unjust enrichment. And if you go into the case of Mafatla, that is 1997, I suppose. It's a 9 judges bench. And subsequently, there is a particular judgment in the case of, let's give it to you. Have a look at this. Hmm. 2009 8 SCC 235, wherein the Supreme Court, after dealing with Mafatla, says about doctrine of unjust enrichment. Because you have to show before this court that you did not charge your people. If you have passed over, then you are not entitled to.
But then if not shifted to the.
Then on one hand, you will be getting it from them. On the other hand, you will be getting it from the state. Wouldn't that be unjust enrichment? Although the Supreme Court out here in this judgment exercised the powers under 142 and directed it to be given to our organization and requested the chief minister to look into it. It is a, this court has doubts as regards this court having that power to do so. But then also the state cannot also keep the money to themselves. The state has also, if you have not empowered to do so, can you keep the money to yourself? It is that, it's a different thing the petitioner may not get, but the state has to give it to somebody. Maybe in this case, it was given to the charitable organizations. You may have to do it to something so that it is for the betterment of the public. Because here is a case where if we refund it also, you cannot refund those persons because those persons to whom you have sold it have already, these persons have already got these are innumerable in number and you can't refund it. So you can't hold it. The state can't keep it. So it has to be for a better, giving it to the housing board or that Mr. Dhar's thing, that is what is that corporation who has no money? Yes. Huh? Okay, we'll have it on 15 then, but they'll look into these two judgments.
Lordship, I have a prayer in connection with item number 10 to 24. But here I pray for 1 day accommodation for tomorrow. But here the notification issued by the state is under question. And the issue is relating to the interpretation of that particular provision of the act. But the learned AG is to address on the issue.
Now, did the state issue a notification?
State has issued the notification that is under challenge. That notice is under challenge.
A notice or a notification?
Notice.
The state didn't have the power, they issued it. The central government, through RTI, we come to know that the central government also has stated clearly that the exemption which were given is basically exhaustive of that item only. It's not enumerative. So as a result, your lordship only wanted to know from the central government, which the central government on 2 occasions has taken time. So basically, the matter was heard at length, and today was fixed for, since it was written also top of the list for delivery of orders.
Well, it was not for delivery of orders. We have a nomenclature for that. We will put it as delivery orders.
Yes.
But the bidder is made, but the fact remains out here is whether the state have the power.
Yes.
The state may have a power for seizing,
Yes.
but has no power for taking other actions.
Because they have made it prohibited.
That power is not given to them.
Yes.
The power is only against the producer.
Yes. And it was basically, it has become prohibitive, affecting my rights under 19(1)(g). In fact, on the interpretation word includes, your lordship didn't go to the judgments also, because I had realized proportionality also. The new 4-pronged theory as laid down in the.
I don't think the proportionality doctrine comes and applies
but
out here. Because
proportionality-
your specific case is this particular thing does not come in.
come in. But as
So
an
then where is the question of
and yes, but as
proportionality?
an abundant
That is
question,
what-
I say the least restrictive measures could be taken, but the fact that the power was not there.
No,
was-
if they have the power
Malad.
to control Mekhela Sadar,
They don't have the power.
it's okay. If they have the power to control Mekhela Sadar, then the proportionality doctrine fails.
Yes.
But if they don't have the power,
Then,
then also the proportionality doctrine need not be invoked.
yes, need not be.
I told them to your junior, Mr.
Yes.
Betala,
Yes,
about
yes,
this.
correct.
So the proportional,
Yes.
we are only on the question of the power.
Power.
And this I have been harping from the first day
Yes,
when the
yes,
matter
yes.
came
Well,
before
in
this
fact, that
court.
is the law actually. We have gone through the Supreme Court judgment.
Because as to whether, because Mr. Nath, your submission has to be limited to one extent. I make it very clear to you.
Correct.
Whether from the definition which is being given out there for Mekhela Sadar, it is clear that it does not include silk, cotton mix.
It includes
It includes silk,
lot.
it includes cotton, it includes silk cotton mix or art silk. But it does not, and then you further say in that particular order it has been mentioned, includes these particular categories, like Dokna and all these things.
Funny yeah. Lot.
So whether, and Mekhela Sadar has been specifically defined out, meaning a particular piece of cloth after being cut and made to the particular thing, not on the person, not on a thing which has been already, or on a particular cloth which is already there, or no, I mean the cloth which is not cut unless it is brought within the size. So therefore, you may have the power if it comes within the ambit of that, and you can show
Mekhela Chador.
Mekhela Sadar that this Mekhela Sadar will come within the ambit of even man-made fiber. You have to show that.
Correct.
Otherwise, you don't have a case. When do you want it?
But for today, if kindly take up tomorrow or
How is it
will be
possible tomorrow? Tell me. You have this court sits till 5 o'clock, then also can't finish the list, and you expect this thing on the file.
But I need accommodation.
Apart from that, we have this top of the list matters which I have to finish it.
No, I need the accommodation for today. In fact, I have been instructed to seek some accommodation for today. Malad. If tomorrow at 2 Malad, or
Because on first, I have a problem with the reservation case is fixed before the division went from 10.
where-
First is,
First is a Thursday.
it's okay, but I've already heard your side. Your junior can be present. We'll have it on first. I make it clear that if you don't appear, I'll issue interim orders.
no, Malad, well, definitely.
Heard Mr. D.K. Das, the learned counsel, appearing on behalf of the petitioners. Mr. D. Nath appears on behalf of the state government, along with Mr. Rahul Dhar appearing on behalf of the Sericulture Department. A request has been made on behalf of the state government to the effect that as the Advocate General is appearing in the matter, some accommodation be given, as on account of his personal difficulties, he is not being able to appear before this court today. The instant writ petitions are part heard before this court. And on the earlier occasion also, this court had granted accommodation to the state. This court fixes the matter on 1st of June 2023. It is made clear that if the matter, any further adjournment is sought for by the state, this court shall consider the interim prayers so made by the petitioners. the matters be listed immediately after the top of the list matters. No, not necessary. Only ask the person to give me that includes judgments.
We have all the judgments. We have the judgment.
You give it to me so that I have a look at it before that.
May it please, Your Lordship.
Yes,
May
Mr.
it please, Your
Bhuyan.
Lordship, I beg to mention item number 40 of the daily list with the consent of the other side. This matter will be adjourned for the day, Your Lordship. And this counsel, Mr. S. Das is not available today, Your Lordship. His name is recorded in the leave note, Your Lordship. Surajit Das.
Who is not there?
Surajit Das, Your Lordships.
Where is his name in the list?
Lordship, he is the newly engaged counsel for
I'm not concerned. It's a
SIDC.
2011 matter, and you know all the list has fallen, so no adjournments.
Lordship, he is out of station. His name reflected in the.
I can't help it. If he has gone out of station, there are many other lawyers who will take it up, and if none appears, we'll dismiss it for default. So, that is your lookout. No adjournment of 2011 matter.
Obliged, Lordship.
May I?
Yes, Mr. Bhuyan.
My lord, I beg to mention for listing of a matter, my lord. Matter relates to disciplinary proceeding and suspension.
Huh?
Matter relates to suspension and disciplinary proceeding, my lord.
Okay, then.
Lord, I am praying for listing, my lord, as an admission item.
Oh, matter of which year?
Lord, current year, my lord, 23.
Then why should this court give you? The matter will come in its usual course.
Lord, some urgencies there, I am without the sufficient allowance
You have been suspended.
suspended.
Chalo, we'll have it on 16th of June.
Obliged.
I beg to mention for listing my lord, two matters. My lord. One is for non-payment of salaries, another is for minimum scale of pay. Leftover matter, my lord, it was earlier listed on 23rd.
Ali, a Upendra sir matter to fix korichu there. Who was there? His counsel. This is Upendas, na? You are relying on Upendas?
No, my lord. I'm government relied on vendors.
You are relying on what? You are which one? The stenographer? Or what is in the foreigners tribunal?
Copy, yes, madam.
Copyist?
Yes, madam.
Okay. Oh, that day the matter was fixed on Tuesday, na?
Yes.
It did not reach. That was matter was listed along with another petition. That's an old matter.
Well,
We'll have it on 14th of June.
right.
You mentioned the matter for upgrading on that day.
Item number 1.
May I please, Your Lordship.
Who is appearing for the respondents? Yes, what is your case?
My lord, my land was acquired long back in the year 1991. Thereafter, one assessment was done, but not a single penny was paid. I think agreed, approached the authority. Nothing happened. Thereafter, finally, I approached the honorable court. And thereafter,
So land has been acquired
yes, acquired.
and there is no award?
No, nothing.
No award.
No award, my lord. It's on record. And they have admitted it. They have filed a very long affidavit, my lord.
Yes, Mr. Barbuji.
Yeah, my lord, I have to make a fair submission before this honorable court. The authorities down below, that is the establishment of the Deputy Commissioner Golaghat, they created all a mess of the situation. That land, my lord, what the petitioner was occupying, it was a government plot of land. and my lord, there were my lord dispute with regard to whether he was occupying his own patta land or government land. But nonetheless, my lord, his land was my lord taken over by PWD for constructing an approach road to the my lord an overbridge.
His patta land.
Yes, his land. Now,
Oh.
my lord, at that relevant point of time, some exercise were undertaken, my lord, by the establishment of the deputy commissioner to formally acquire that land. But that didn't attain any finality and it got lapsed, my lord. It stands as it were there, my lord, at that point of time. Now, having approached this honorable court, the issue was taken over by this honorable court, and during the proceedings, my lord, the deputy commissioner was also personally summoned before this honorable court. And my lord, an order was passed, whereby my lord, the deputy commissioner undertook, my lord, that he will now go for a de novo exercise. And then, my lord, since the land was, my lord, occupied, my lord, the possession was taken over. So the petitioner will be entitled to requisition rent for the period till when it was, my lord, taken over. And authorities say, my lord, that some portion of the land was later on released. They found, my lord, the PWD authorities found that some portion of the land was not required. Accordingly, it was released. So for that quantum of land, definitely, my lord, the petitioner will be entitled for zirat compensation as well as requisition land. Now, so far as the other party is concerned, my lord, I am told that the deputy commissioner has drawn up a formal proceeding under the Land Acquisition Act 1964, and it has been sent to
When?
my lord. It was precisely, my lord, in the year 2021,
And how did you do it under the 1894?
1964 Act, 1964.
Assam Land Acquisition and
Assam Land
Requisition.
Acquisition Act, because that act is also, my lord, holding force, my lord. Is holding force in the field, and there are notifications, my lord, issued.
Then what happened thereafter?
My lord, thereafter, my lord, we have to take, my lord, the updated instructions, my lord.
Huh?
We have to take the updated instructions.
Updated instructions for what? You have not till date acquired the land. If you have not till that acquired the land, then obviously he is entitled back to the land. You want the land back?
In case nothing is paid, yes.
Return the land.
Now, my lord, an amount, my lord, I am talking at my lord, an amount of rupees, my lord, 17,49,686. My lord, that has been earmarked, my lord, for land acquisition compensation.
Then
And my lord, the amount of rupees, my lord, 51,529, that was, my lord, calculated, my lord, towards the requisition rent. Now, my lord, I will have to take instructions from the revenue department. My lord, what has happened thereafter? Because I have a communication, my lord.
no, Mr. Borbujari. These are top of the list matters.
My lord,
We will declare that the land belongs to him. If you have not paid now, till now. Even after orders being passed by this court. Where is the direction?
my lord, one meeting was held.
Hmm.
And in that meeting, my lord, decision was taken. And decision, the minutes recorded, came before this honorable court in the form of letter, my lord. It is annexed to the affidavit that was filed by the Golaghat Deputy Commissioner. It is available at page 146, next 194.
Have you initiated the proceedings under section 6?
Yes, my lord, Lordship may kindly.
Where is the notification to the effect?
In between, my lord, the department has also filed an affidavit.
Some land acquisition and acquisition.
Lordship, for a moment, my lord, Piruj's order dated 18/12/2019. Order dated 18/12/2019.
Yes.
My lord, pursuant to this order, my lord, Lordship, may kindly see the second paragraph. My lord, I am reading it. As the matter itself is pending since 2014, and the claim of the petitioner is of the year 1991, when the land was acquired, we direct the respondent authorities conjointly to take a final decision among themselves and file an affidavit by PWD before the next date fixed. In the event the affidavit is not filed, the appropriate cost should be imposed. Now thereafter, my lord, a meeting, my lord, took place between all the stakeholders, my lord, including the petitioners. And there, Lordship will kindly see, my lord, an affidavit to that effect has been filed by the Revenue Department. That affidavit, my lord, is dated 18/2/2020.
Yes, what is it?
An affidavit, my lord, dated 18th of February 2020.
What does it say?
My lord, in that affidavit, by that affidavit, my lord, we have brought on record the minutes of meetings, my lord, held on 18/1/2020.
No, you could, Volume 2 funding.
মাটিটো ললো নললো সেইটো কথা ক'ব লাগিব because requisition মেইনটো কথাটো আহিলে যদি মাটিটো আমি লোৱা নাই তাক ওলাই দিলো যিটো মাটি নালাগে সেইটো চালে লগ কৰি থৈছিলে সেইটো পিৰিয়ডত আমি ৰেণ্ট কৰোঁ and that person of that which has actually been taken over from the position of আমি জানিব লাগিব সেইটো
So, from these particular documents which you have given, have you published it or is it in the lying out there in the treasury?
It is in the Assam Tribune.
Fantastic.
It was in the Assam.
Now, once you have done that, by virtue of section 6, the land already vested upon you. Now, when is the compensation?
subsequent instructions, my lord,
We impose the interest upon the hearing official, the deputy commissioner, from collect it from his salary. Matter over. Why do you need all these complications out there? It is a simple case that you have exercised the power. I'm not looking to other aspects. You have already taken by section 6, by virtue of section 6, the land already vests upon you. So you, once it has vested upon you, then you are liable to pay the compensation. Now, if the compensation has not been paid, for the first year, it will be 9%, and the second year, it will be 15%. That's we have to follow as regards the interest from the Land Acquisition Act. And then this interest, you get it from the deputy commissioner who is the hearing or from your revenue secretary who has done it. But you have to pay him within how much? 1 month, 2 months, 2 months.
Yes, Lordship,
There's nothing else. You have the moment you have issued that notification, the land has vested upon you. You are to pay for the first year. This is 9%, and the second year onwards, it is 15%. Why do you need into all these voluminous papers to be looked into?
because my lord, Lordship,
How can you just know? You justify me. After the issuance of a notification under section 6, can you say that you are not going to pay the compensation?
No, absolutely not. Because
Then, if it is to be paid, you ought to have paid it on which date did this publication happen? On 10/12/2021. You have not paid till now. So the first year, till 10/12/2021, it will be 9%, and thereafter it will be 15%.
My lord, yes, my lord.
What else is required to be looked?
Lordship is correct, my lord. I'm not. Lordship, what I am saying, my lord, let this two, my lord, notification issued under section 6 be brought on record by the deputy commissioner.
Why?
No, my lord.
Now, do you want to further delay it?
No, my lord.
Then-
Let me get the.
Now, when
instruction.
this notification was already issued on 10/12/2021, why has that been brought on record till now?
My lord,
Why it was not brought on record till now? If you have issued it.
well, let me get the instructions from the department. Lordship will kindly bear with us, my lord, for another 2 weeks. My lord,
No,
thereafter Lordship
no,
will-
no, 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 no.
Lordship will dispose.
I will keep your two. The two, I will keep it, not the weeks. The two will be at 2 o'clock. Get your whatever instructions you want till 2 o'clock. Nothing more than that. Nothing more than that. What instructions you have to get it, get it. Else, I pass the order, go to the division bench wherever you like. But get your thing, the state has to pay the interest. And if the state, I give the liberty to recover it from the salary of the deputy commissioner, concerned deputy commissioner, as well as the revenue secretary who is responsible. Take it up at 2.
Because
This is my order.
now here the beneficiary is, my lord, the public works department. PWD is the beneficiary. The lordship will also hear the PWD also, because ultimately they will be, my lord, paying the amount. And my lord, whether, my lord.
Mr. Dhar, where is he? Oh, you are there. Then.
I'm for, well, that two letters I have handed over, my lord.
You see, the beneficiary is the PWD is a different thing. The beneficiary comes into the scene after you acquire. So we are concerned with the relation between you and him. Therefore, if you see in the earlier provision of section 54 of the earlier act, or even in 50, the beneficiary is only made a party in the appeal or in a reference also, if or in a proceedings under the Land Acquisition Act, if there is a question of the amount getting higher than that.
Yes.
Nothing more than
Only
that.
that to
We are
confirm.
not concerned. It is absolutely your fault in not paying him the amount. So you have to pay him. And once we give it, then he has a right to ask for more money. Now you are stopping him to get that. He can very well file an application before you for extension under section 12, which he is not being enabled to do it. You have not passed an award. You should have passed the award. You have not done that. You do it within 1 week from there, and thereafter he has to get the. This is not a thing that this is a matter of 2014. My goodness.
Yeah, so therefore, my lord, my lord.
So two,
lordship
no,
will
two.
Kindly.
No,
No.
Mr. Barpujari, I'm making it very clear.
I
2 is
have
the
to-
time.
I have to get hold of the record, my lord. Let me get hold of the.
Whatever
record.
you
My lord, I will
get,
summon the record.
whatever you want, get it by WhatsApp. We are in an advanced stage now. But at 2, nothing more than that.
Well, for the time being, my lord, I'll take just those two documents, my lord.
Yes, you get your instructions also.
Shall we leave, my lord?
Now, this is an order passed under section 3 for the purpose of payment of the requisition rent of 51,000.
Yes,
And you have already fixed it out.
yes. It was sent to the department for approval, my lord.
You're not concerned with your approval or not. You want to bring those officials also to proportionately share the burden of the interest, you can very well do so. I give you the liberty. Thereby saving Mr. Arbor Pujari's client to a particular extent by sharing the burden of the proportionate interest. We'll take it up at 2.
Those lordship.
Item number 2 and 3.
Met with the lordship.
Yes.
Before my
This is
lord,
relating
senior
to my-
starts, my lord. This matter was heard at length and was reserved for judgment. Now it has come up after a very long time. Now this court directed us to produce the records and it was with us during the time of hearing. Now, with the elapse of time, we returned the records, my lord. My lord, would kindly grant us 1 or 2 days time, my lord. We'll recall the records and we'll be able to appraise this.
You know, this matter came up day before yesterday in the list. Absolutely. Day before yesterday, it was listed that this matter will come up today. You knew about it. And there was on the top of the list, it has been mentioned that no adjournments in the top of the list matters. Yes, Mr. Saik. Yes.
An advertisement was issued, my lord, on 12 June 2018 by the Indian Oil Authority, inviting application for appointing 66 distributors in different places of Assam. The petitioner also, my lord, applied in the category of, my lord, Durgam Kshatriya Vitra. Advertisement, since it is in Assamese, my lord, Assamese proceeding, I have not annexed the portion, but at the time of hearing, I can place it, my lord. The petitioner was considered and his name was placed at serial number 1 after selection, my lord. That is, my lord.
Yes, why you are challenging the respondent number 4's?
Yes, my lord, because as per, my lord, the guideline, she is not entitled to, she is not resident of that particular area. I was placed in serial number 1.
Eligible applicants residing in the concerned Gram Panchayat of the advertised location. That is it.
Yes, she is not.
We are concerned with clause
they are-
15C Roman 1.
Yes, ma'am.
Your case is that he or she, the respondent number 4,
Yes.
is not a resident of the concerned Gram Panchayat of the advertised
Yes,
location.
my lord. Haryana
Now, what is the
says-
advertised location we are concerned?
I want to first place the law, page 22, my lord.
Page?
Page 22,
Yes.
not available. In the middle, my lord, inter-se priority in draw of lots to Durgam Kshatriya Vitra. Inter-se priority is given in the draw of lots to the eligible applicants for the Durgam Kshatriya Vitra location only as per the following order. 1. Eligible applicants residing in the concerned Gram Panchayat of the advertised location. 2. My lord, eligible applicants residing in the concerned revenue subdivision of the advertised location. If one is not available, then my lord, two will be considered. Thereafter, my lord, 3. Eligible applicants not residing in the concerned Gram Panchayat or in the concerned revenue subdivision of the advertised location. So, my lord, this is the, my lord, criteria one has to be fulfilled. In this
No, a
situation-
person who is not a resident will also be considered, but his marking will be less compared to the person who is there in the Gram Panchayat.
Exactly.
Yes.
Your
Then,
lordship is right. Accordingly, I have applied. When, my lord, result has come. I
where is the
have placed the serial
advertisement?
number.
Where is the advertisement?
Advertisement, I could not, because it's a huge. my
No,
lord,
then
Assam-
where can we come to learn that
Yes, my
which
lord.
is
This
the
is the copy I
particular
made.
area we are concerned?
Yeah, that I will place, my lord. This is the advertisement, my lord. In original, I am sending.
No, which area we are concerned?
Jamla area.
Gamla.
Jamlai. That is in serial number, my lord. In the advertised location, my lord, Jamla area, near, my lord, this focus organ or something. I will place it, my lord. So, my lord,
Yes, then
yes, here, my lord, that
type of area is Durgam,
Durgam.
Kshatriya Vitrak, and we are concerned with the location is Jamlai. Okay.
Yes,
Gram Panchayat is Jamlai, Kalyanpur.
yes, ma'am.
Block is Samboria, district is Kamrup, Assam. Fantastic. Now,
And, my lord, as
who
per
is
advertisement-
Dipti Das?
Dipti Das is respondent for, my lord.
Okay, Dipti Das is respondent number 4.
4.
Now, whose photo is there at Annexure 1, page 8 of the affidavit filed by the respondent number 4?
Respondent for, my lord. Here, if your lordship come to
Whose
this
photograph is this?
respondent for
Who is appearing for respondent? Okay, is this your affidavit? At page 8? Or running page 88?
Page 8, my lord, she is my respondent number 4.
Okay. Now tell me, where do your husband resident of village Gopalpur? So you don't fall within the, and what is your Gram Panchayat?
My lord, originally, my lord, she belongs to Gopalpur, my lord. That page 11,
That is what I am seeing, page 8 of your affidavit.
Gopalpur.
It has been shown that she is a resident of village Gopalpur, P.O. Mirza.
PS Polasbari.
Whether the Gram Panchayat in which the applicant resides is same as the Gram Panchayat of the advertisement, you say yes.
Yes.
Yes. Okay. Whether the subdivision where the applicant resides, residence is located is the same subdivision of the advertised location? No.
My lord, I enter into lease agreement, and therefore, my lord, thereafter, I am residing in particular this area. So what page, my lord, 11 is concerned.
or go down.
Prior to filing this application, I entered into agreement on 4/7/2018.
Agreement cannot be a residence, leaseholder. When did you enter into leaseholder?
This agreement entered on 4/7/2018, and
Address of the location for the LPG godown is village Jamlai. But your village is different,
different.
Gopalpur.
Thereafter, I am residing as a rent as a
But does this village Gopalpur and village Jamlai fall within the same Gram Panchayat? Now petitioner, she a resident of Jamlai?
No, my lord.
Where?
Second, see, Gopalpur Mirza. All right.
About you,
Oh, me, my lord, yes.
in Jamlai.
Jamla, and my fathers have got land also for giving for go down. And she has taken a plot for.
So you are a resident of Jamlai?
Yes, ma'am.
So you come within criteria 5.1.
That's why I
Number
was
one.
placed in serial number 1.
Yes, so you should be at serial number 1 and you should get it
Yes,
when
ma'am.
both are equal.
Yes.
Okay, now,
and lordship, page 24 in my affidavit,
Hmm.
one certificate issued by the my lord circle officer, and here saying, my lord, I am a resident of village Jamlai. That advertisement by criteria doesn't say that permanent resident, only resident. I am not permanent resident of Jamlai, but living as tenant in the area, and therefore, my lord, saying that he is also resident of village Jamlai, page 24. And this was issued on
Yes, yes. Government land.
and where is Nagarbera?
Nogarbera, my lord, post office, my lord, post office. So this Jamla is located under Nogarbera area.
Revenue circle.
Also Russia. And the circle officer issued this certificate, and that was prior to submission my application, my lord. Application was submitted.
What is this page 25?
Page 20 license, my lord. This is concept schedule.
So your income tax return is also from Jamlai.
Jamlai. This is Jamlai, village Jamlai shown. And thereafter, my lord, on page 26, NOC also issued Jamlai, Kalyanpur GT.
And what is this memorandum of agreement at page 109? Means running page 109, page 29. You have entered into an agreement.
Yes,
It has been done.
Yes.
appointment.
Okay.
And this, my lord,
It was issued on 19. And for how long? Mr. Counsel, so till how long?
no, thereafter, my lord, page, my lord, 28, appointment letter also issued.
Understood. Since how, for how long is this advertisement? For a lifetime?
Yes, ma'am.
LOC.
This is the LOA with the IOC. This is the LOA with the IOC. until
For how long?
till the time she expresses her disconsent to run the.
Okay, for all time,
All time.
till she is alive.
And lordship,
And after alive also, dead also, it will go to the legal representative.
and this is
So
my
it
lord,
is something like a land.
and so far, my lord, this memorandum of understanding, this already been set up and it is smoothly functioning without any hindrance from any corner else. And I have deposited.
Now let us see the affidavit of yours. What do you have to say?
Madam, pursuant to her selection in the draw of lots, madam.
Why have you not selected the petitioner and selected him?
Madam, what has happened is the petitioner submitted two applications. In one, he wrote his father's name as Santosh Paul, where in the another, he wrote is that Santosh Pal. Now this system, because of the Pal and Paul, both of the applications were accepted, whereas the guidelines say that if you file more than two application forms, one of the
More than two or more than one?
more than one application form, I'm sorry, madam, more than one application form, both of them or all of those will be clubbed together and taken as one. So when he was selected in the first draw of lots, later on a complaint came from another candidate, and that's why this anomaly was found and he was rejected and he was allowed to participate in the second draw of lots along with the other candidates. Then the private respondent was selected
In the first draw of law.
in the second. Because first it stood cancelled because the petitioner was selected based on his two applications. After the objection was raised, after his selection in the first draw, after the objection was raised,
What is this first draw and second draw?
my lord, lottery is conducted, my lord. All of their names are put together. Lottery is conducted. One of the names is picked up. He or she is selected. Then we go for FVC, field verification. So he submitted.
But before that, do you not decide the eligibility?
No. Because
So
my
a
lord,
person who would not be eligible also may,
My
with
lord,
the
we-
draw of
my lord,
lots,
we
be-
simply decide the eligibility based on the information given in the application form. We do not. go to
understood,
the
no
field
problem with that. But for the purpose of participation in the draw of lots, do you look into the eligibility?
No, ma'am. No. Because tomorrow if 100 or 1,000 applicants come, ma'am, so it will be a humongous affair.
So you put everybody's name in that glass jar.
Yes,
And after that, you pick one up.
one.
After that,
After that, we go for the field verification of his credentials.
Hmm.
If those are found to be in order, we issue the LOI. Once he or she adheres to the terms and conditions.
so
of
the
LOI.
petitioner, did he come in the first draw of lots?
Yes, because
And as such, but you rejected on the ground of two applications.
Yes. So in the second, we clubbed both of his applications together and we allowed him to participate.
Then why didn't you do it in the first instance?
My lord, we didn't notice it, my lord. It was, we noticed it only when,
No, but if you have the power to club, why it was not clubbed?
because my lord, there was a difference in his father's name, my lord. That's why the system
The
didn't.
difference
capture
is
it.
with the A or
Yes.
with the vowel U.
Yes, my lord. Because of that, the system didn't capture it, my lord. We have stated so in the application.
Understood, but how did you club it later on? With the consent of the petitioner? Or did you have the power to club?
Well, later on, when we noticed the anomaly, that both of these persons are one and the same, then we took only one application form.
Then where do you get that power to do so?
Well, it is there in the guidelines, my lord.
Show me. So the petitioner number 4, respondent number 4 will only come when we have the second draw.
Second. Yes.
If we go and see that your action as regards the first draw of lots is illegal, the petitioner is entitled.
Well,
That's your case, madam.
yes.
Little bit different, my lord, because regarding the clubbing of two petition, my lord, as per law, my lord, that,
No, no, no. That is why we are going to look into now the clubbing.
yes, ma'am.
So your thing is specifically is that I am eligible as per the first draw of lots, and as such, I should have got it.
Yes, ma'am.
And as such, the second draw of lot was not necessary.
Necessary.
So that is your case.
Yes, yes.
So we are looking
And I-
now on the
I
question
think
is
that-
whether they had the power to club. And
Yes.
if the power had been, was there to
Yes.
club,
Yes.
why that clubbing was not done earlier?
Yes, that's right.
Let's see
And
that. Yes,
I showed
Mr. Your name?
P. Bharadwaj.
What do you want?
May I show the
No,
provision?
it is
my
here,
lord?
na? These tender conditions,
May I
brochure
show the
for
provision,
underlying
my
guidelines. It is there to the petition and Annex 2. Find out.
May I show the provision, my lord? Clubbing.
Let him show.
Madam, she has not annexed the entire brochure.
Okay, you have done it. You have also not brought in that.
No, madam, but we have stated that we have, because we have annexed both of her applications, which shows that her
No,
father.
we are only concerned with clubbing.
Yes.
One application per applicant for location. Applicant should submit only one application for one location. Okay. We are not concerned with candidate applying for multiple locations. But where is the power to club?
Because only one application was allowed, madam.
Understood. Where did you, how did you club? And if you could club it earlier, why not you didn't do it
I
earlier?
don't really understand, madam. Madam, the system didn't capture it because I have annexed both of her applications, first page, madam, because of his father's name, madam, Paul and Pal. Once the draw was carried out, he was selected. Then a complaint comes from another applicant, and another applicant says that he has done such an act. He has got the opportunity of 2 applications in the entire lottery box, man. So
you cancelled the entire first lot.
entire first lot we cancelled.
Where have you stated that in your affidavit?
Melody, page 3, page 2, para 5, down below.
Your affidavit has been filed by Ranjit Borgohain.
Yes. Yes.
Okay, paragraph 5.
Before that, para 4, my lord, para 4.
Okay.
That the petitioner had submitted 2 online applications, right number so and so, as per Unified Guidelines for Selection of LPG Distributorships, October 2017, clause 10.4.2. Only one application per applicant is allowed for a
Wait.
single-
Where is the 10.4.2? Where is this? It is not here, 10.4.2? Why it is not here? 10.4.2, where is it? We had 10. 10 is only non-refundable one.
Perhaps I've given the June 2017, my lord. There's another October 2017.
This is June 2017.
Madam, all of these were present in the records, madam. That's why I was.
I'm not
handicapped.
concerned with that. So you have not, you don't have that basic out there. Then why did you cancel it? You couldn't have cancelled it.
If I may continue. 10.4.2, only one application per applicant is allowed for a single location. In case. more
Madam,
than-
you have these guidelines?
Yes, my lord.
A copy of those guidelines?
I have,
She also has given June
I have
2017.
written in my affidavit. And
No.
my lord, that 29-1, filed on 29-1-2021, reply,
29/1.
21. Filed on 29 January 21. Last affidavit reply.
Yes, she has given
Page
some
2.
guidelines of
Page
2006.
2,
This is
yes.
June 2016.
Page 2, my lord. That as regards to the statements made in para of the affidavit in opposition filed by respondent, referred to as an affidavit, the deponent begs to state that as per clause 6.5 of the Unified Guidelines for selection of LPG distributorship 16 and clause 10.4.2 of the Unified.
Why
Guidelines,
haven't you brought, which is the
Demonstration of
guidelines applicable as per the advertisement?
Applicants,
Madam, this will be October 2017, madam.
Where is it?
that was applicable at the time. Applicants should submit only one application for one location. In case more than.
Madam,
one
you are
application
reading
is
from which document?
My lord, that affidavit in reply,
Filed on?
filed on 29th of January 21.
Or affidavit in reply at page 145. 145.
Last document.
What is the 145? Ah, 145. Yes, you have read it.
Paragraph 3, my lord. Yes.
Applicants should submit only one application for one location.
In case more than one application is received from an individual, all the applications should be clubbed together and treated as one application. In such cases, application fees received against all other applications would be forfeited.
So this is the power to club.
Actually, what is the reason, my lord? They are living in very interior place. They thought that once it is sent, maybe it has not gone application. Again, they have sent, because they are also little bit little question.
Okay, now show me where is the draw of lots. The clubbing has to be done prior to that. So that means there has to be a verification prior to that. Why didn't you verify it earlier?
We don't go for verification early.
No, then then you have no other authority but to check it out.
No, my lord, the guideline itself says.
No, does it
more
say
than
that if
one
they, no,
application, my lord.
understood, but does it say that if there are two applications, you are going to reject it? That the lot will be rejected.
My lord, only one application.
Mr. Bharadwaj,
per
kindly
applicant.
answer this question. Does it say that, does your guidelines in any manner say that if there are two applications, you are going to reject that applicant,
No, my lord.
or you are going to reject that lot? Does it say?
But my lord, one application per applicant and the advantage was given to him, my lord. So the other, immediately the other candidates suffer, my lord.
Understood, they will suffer, but that is why it was your responsibility under 10.4.2 for the purpose of looking into it and verifying that there are not two applicants, or you should have exercised the power that if there is two applications, it will be
My lord, it
rejected.
didn't come into light because of the name, my lord. We have annexed the first page of our application. My lord, the rule says more than, suppose she files multiple applications, my lord, and each and every application are same, my lord, each and every words are same, my lord. Then we'll club it together, or perhaps we could have construed it as one application. But here, the father's name is different. So that's why it didn't.
There is difference with the vowel only.
No, my lord, it makes a lot of difference, my lord.
No,
Father's
but
name,
where
my
is
lord.
the power to cancel the lot on the basis of one
No,
application?
even though that is not stated, my lord, the one.
Then
which
how do you
precedes
do
my
it?
lord,
Wouldn't that be illegal?
The one which precedes it, my lord, that one application per applicant. My lord.
I understand what you are saying, but where is the power to do that? To cancel a lot on the basis thereof. It is all luck.
But with her added advantage, my lord.
I didn't know it was your responsibility. Yes, there was one person, one applicant. Then why did you club it? And why haven't you brought on record those guidelines? Then why should this court look into all these things? Cancellation of the lot is illegal. Lot. Do we allow this petition?
My lord would allow me to appraise this court with the guidelines of movement.
Why haven't you done that?
Let me bring it.
We'll impose a cost upon you.
My lord, it was not, we had to
No,
return
we
it
had to
because it
impose
went
the
into
cost.
cold storage for a very
Today,
long period of time.
madam was appearing, madam's fees has to be paid. You pay the fees of Mr. So-and-so. Both of them pay the fees to impose that cost. 50,000 and how much? 50,000, 1 lakh. You pay. We grant you the
I have-
adjournment, but
Lordship,
one
my lord.
1 lakh. 50,000 each you pay.
Lordship, I have already invested huge amount, my lord.
Oh,
I
so
myself.
if it is illegal, it is illegal.
Because, my lord,
You want that money back, you file a suit.
because, my lord,
Go
so
there.
so far appointment letter is concerned, Lordship, case 28, dated 30th August 2019.
Mr. Counsel, your appointment, isn't it made categorically that it will be subject to the outcome of the writ petition? Look here, it is clear.
It is stated in the LOA.
Then, how does it matter?
But
How
this,
much spend you have made it, that is your lookout. I'm not concerned with those things. You have spent it at your risk. You shouldn't have taken it. The matter is litigated. Why should I take it? You get 50,000 from him.
no,
And
this-
50,000
this-
she will,
this
so
is
that
not
you
related.
accommodate it.
Dispose of. Because Lordship, this petition number 4406 not covered my case. It has been another situation, my lord. And this appointment letter, 30th August 2029, prior to filing this petition is not challenged. in this case. My appointment letter has not been challenged. Petition, my lord, filed thereafter, after my appointment, filed on 15/11/2029. And prior to that, on 13th August 2019, my appointment letter was issued.
Yeah. Kindly see the order of this court on 6/2/2020, where it has been mentioned that from the submissions of the learned counsel in my considered opinion, no further interim protection is required. Inasmuch as the appointment letter dated 30/8/2019 itself indicate that the fate of the distributorship is subject to the final outcome of these writ petitions. Then these type of arguments doesn't hold good in this court. 50,000, willing?
My lord, I was unaware that the matter was listed day before yesterday, my lord.
Not day before yesterday, it was not listed. The list came out day before
Oh,
yesterday.
my lord.
So you pay 1,50,000. 50,000. You don't want, I suppose, this 50,000 from him.
But I have loser, my lord.
You don't want.
Already, my lord, it is
So you are saved, Mr. Counsel.
well settled. my
Only
lord.
50,000.
This will come from Bhavani Madam. my lord. Very short period of time is required.
Okay, we'll take it up at 2. Get it from Bhamani meter. 2. No adjournments on this.
Yes, my lord, because we had some
Yes.
modern.
Get
one,
all
yeah,
your
my lord.
guidelines and all. We'll take it up at 2.
Yes, sir.
No, 4. Yes.
The matter regarding the issuance of my death certificate to the wife,
Death certificate?
death certificate.
Death certificate for what?
Because the death certificate is necessary for applying pensionary benefit.
Why haven't you got the death certificate of whose?
My husband, it was issued to the brother of the my brother-in-law. So the respondent denied to issue second certificate.
Yes, madam. Why you are not issuing?
Under the law, it is can.
Already it was registered in the name of the brother, lordship.
So what? I don't understand the concept of issuing only one death certificate. There can be very well the duplicate certificates. You can very well mention as duplicate, you can do it. In fact, if you see out there in Delhi and all, it is only the question of how much you want to pay. If you pay 100 rupees, you get 1. If you pay 1,000 rupees, you get 10. So what is your problem with that? Death certificate is a death certificate.
Yes, Lord.
What is this?
The similar lordship.
Lordship order.
Didn't it, what my opinion, doesn't it matter? For these, you want to show
Lordship
judgment?
direct the authority, lordship.
Huh?
Lordship may direct the authority.
Absolutely. Heard Mr. D.F.M., the learned counsel appearing on behalf of the petitioner. Miss
D. Bora.
D. Bora appears on behalf of the respondent numbers. What about notice has been issued?
Yes, my lord.
What happened? Notice received?
Lodging of course order dated 28/10/2021.
Issue notice. Then service?
Service is completed, my lord.
No affidavit filed by respondent number 1. Service, no affidavit filed. So and so. Peruse reveals the prepaid. Okay. Service complete. Miss D. Bora appears on behalf of the
All
respondent
the
numbers 1.
respondents, Lord.
All, no, you are not all. 1 to 4. None appears for the respondent number 5 on call.
Oh, yes.
The petitioner herein is the wife of Minaharul Islam, since deceased. During the lifetime of the petitioner, of her husband, there were certain disputes, matrimonial disputes. Be that as it may, the petitioner still continues to be the wife of the petitioner. Be that as it may, the husband of the petitioner expired on when?
25/8/2020.
25/8/2020. Leaving behind his mother, the petitioner, and her son. The husband of the petitioner during his lifetime was the assistant teacher of Galande LP School. And upon his death, there's an entitlement of the petitioner to the pension and the pensionary benefits. Be that as it may, the petitioner herein had applied for the death certificate of her husband so that she could apply before the authorities concerned for the pension and other benefits to which her husband would have been entitled to. However, the respondent authorities, instead of issuing the death certificate to the petitioner, have issued the death certificate to the respondent number 5. Being aggrieved, the petitioner is therefore before this court. This court, I've heard the learned counsel for the parties. Taking into account that the petitioner is the wife of late the petitioner has an entitlement to get the death certificate of her husband. Even assuming that the death certificate had been issued to the respondent number 5, this court finds no reason as to why a duplicate death certificate cannot be issued. Duplicate? Should we use the word duplicate?
Under the Act, certificate can be issued, which is taken into consideration under the Evidence Act, under Section 17.
Why another certificate cannot be? No. Finds no reason as to why another certificate cannot be issued. Now, why a duplicate certificate cannot be issued? Now, why a second certificate cannot be issued to the petitioner? At this stage, this court further finds it relevant to take note of the Section 17 of the Registration of Birth and Death Act 1969. Which stipulates that any person can obtain an extract from such register relating to any birth or death. Subject to that no extract relating to any death issued to any person shall disclose the particulars regarding the cause of death as entered in the register. Subsection 2 of Section 17 of the said Act of 1969 further stipulates that all extracts given under Section 17(1) shall be certified by the registrar or any other officer authorized by the state government to give such extracts as provided under Section 76 of the Indian Evidence Act 1872, and shall be admissible in evidence for the purpose of proving the death, birth, or death to which the entry relates. Taking into account the mandate of Section 17 and the certificate so issued is an extract of the contents of the register, which is required to be maintained in terms with the Act of 1969. This court does not find any reason as to why the respondent authorities have not issued the death certificate to the petitioner. Accordingly, this court therefore disposes of the instant writ petition, directing the, which one?
That's number 2 and 3, Milord.
Ask one. How many people are you going to disturb for one death certificate? Huh?
2, Lordship.
Fantastic.
Judge Joint
Two.
Director.
Directing. The respondent number 2, is he the person who issues the death certificate?
Yes.
To issue a certificate, death certificate, a fresh death certificate, a death certificate, issue a fresh death certificate to the petitioner containing the extracts of the register relating to the death of her husband, late so-and-so. The same shall be done within a period of 30 days from the date a certified copy of the instant order is served upon the respondent number 2.
Published.
This order is much better for you.
Hi.
Make clear, Lordship. In respect of item number 5, on instruction from learned Advocate General, my lord, I have a humble prayer before Lordship, my lord. His out of station matter may kindly be taken up on Friday, my lord. That is the only prayer.
What is this matter?
Lord, perhaps it's a tender matter. Tender matter.
matter, Your
So
Lordship.
water resources tender matter, Lordship, for construction of sluice drainage, Lordship.
Mr. Goswami, please don't mind. This court is not going to grant any adjournment, be it the Advocate General or AI, in the top of the list matters. Sorry.
My lord, in
I
fact,
am going to
earlier,
take
in
it up.
fact,
No, I'm not concerned with anything else. I am only concerned that top of the list matters. I'm not going to grant any adjournment. And I make it very clear. The Advocate General may be appearing in any matters. And if this court wants his appearance, this court will put it in the order that his appearance is required. Otherwise, his appearance is simply an appearance as a senior counsel for the states of Assam. That's all.
my lord,
I am not going to grant an adjournment on
As-
these matters.
as-
Yes.
As requested by the state government, my lord, the Advocate General appeared
The
earlier.
state government can choose anybody anywhere.
And my lord.
That is their lookout. They made ask the Advocate General for what? There's the
my-
rule, as a rule or notification, rule being issued,
My lord,
challenged
in
out here.
fact, my lord, earlier occasion, my lord.
And if the
matter
rule has
was-
been challenged, we place it before the division bench.
My lord, matter was heard finally and.
Let it
the
be heard,
judgment was
whatever may be.
entered.
This court has been now
Only,
given. No, I'm
Lordship will
sorry.
take it up only Friday, my lord.
No Friday business.
And in the,
I am not going to grant any adjournments on these matters.
then, my lord, his part may be heard on Friday, my lord.
Huh?
His part, Advocate General part.
Okay.
because that
We will,
part.
we may keep it for orders on Friday. Yes, you argue.
Wait, please, Your Lordship. There was an NIT issued by the Water Resource Department for construction of a sluice gate.
Huh?
Of a sluice gate, Your Lordship.
Sluice gate, yeah.
Yes, Your Lordship. Now, what happened, Your Lordship?
Construction of a sluice gate at Padunath Mandir area to check backflow of river Brahmaputra.
Right, Your Lordship.
Then,
Your Lordship, I submitted my bids. After I submitted my bids, Your Lordship will be pleased to look at page 98, Your Lordship. There was an email, Your Lordship.
yes,
By way of this email, I was intimated that, may I read, Your Lordship?
it is informed that your bid with ID number such and such has been successfully submitted on 9th February 2021, 11:05 AM. And for further information, you are asked to get in touch with the tender inviting authority. Your lordship will kindly note the time, your lordship. Then the next page, your lordship,
What is the time?
11:05. This is relevant when I'll come to
That is
the,
your date of submission.
and 11:05. Yes, your lordship.
You submitted at 11.
Yes, your lordship.
Okay.
On 9th February, by email, I was intimated, your lordship.
Then,
Nothing happened, your lordship, for long period of 4 months.
oh,
Then on 3/6/2021, the petitioner submitted a representation that is at page 99. Your lordship.
hmm.
The representation he has
With reference
submitted,
to this to inform you as tender schedule, the opening date of the aforesaid bid was fixed on 10/2/2000. However, after expiry of more than 4 months, the bid is not open till date. Now, by this kind of arbitrary act, you have categorically violated your own obligatory manner, which is very. Okay, then,
your lordship, as I have submitted it, on 4th June 2021, that is annexure 5, page 100. They have
yes,
submitted, it is to inform you that your bid has been opened.
yes, read it. Tell me next.
Now they say that my bid was admitted on 4/6/21.
You are informed that
Email
your
was sent
bid
at
for the
4th
above tender has been accepted during definite by the end. So as on 4th of June, tender evaluation, technical evaluation has been accepted.
Yes, your lordship.
And
And they said that the
above
financial
tender
bid
has
will be
been
open at
revoked from
3:30.
Technical evaluation to technical bid opening.
Yes, your lordship. Now, at,
Well, yes, now you are concerned with 102.
yes, your lordship.
Then what
On
happened?
the same day, all of a sudden, without any rhymes and reason, they again say that this tender has been revoked. Fine,
For
they have not cited any
technical
reason.
from, no, revoked from technical evaluation to technical
In
bid
bid
committee.
opening.
In revoked from thing. Okay, then you are,
Your lordship, page 104.
yeah.
They
Then-
say that it is to inform you that their bid has been opened and updated summary by constituted committee. Your bid has not been admitted.
Wait. 9th of February, 11:13.
Yes,
This is your bid. Is referred to the bid number 106581, dated demand 1105. But you see, your bid was submitted at 1105. What is this 1113?
which page is your lordship?
Kindly come to page 102. You asked this court to keep in mind the time.
Yes, your lordship.
I've kept in mind the time while reading it.
Yes, your
So
lordship.
while keeping in mind, it was there at 9 February 1105.
Yes, your lordship.
Now it is 9 February 1113.
Yes, your lordship.
What is the difference?
The difference is that, your lordship, they have said that it was revoked within a span of, your lordship, no, that was on 9th June, your lordship. Now they come up on 4th June and they say.
No, Mr. Counsel, kindly come to page 98.
Yes, your lordship.
Don't ask this court unnecessary to remember some things.
I'm sorry, your lordship.
Yes, page 98, what is the time? 9th February 1105. Okay?
Submitted. That is the time of the. time
Absolutely.
Yes.
Come 102. What is this?
Please refer to bid 106581 dated 9th February 2021, 11:13 AM. Submit.
What is this? Why did you ask this court to think about the time?
Because, your lordship,
Because you forgot.
I'm just coming to that, your
Yes.
lordship.
Okay. Let us see what other case you have.
Your lordship,
Yes.
on 4th June, they have said me that the.
That I read it.
Financial bid will be open at 3:30. And
Why? This email is issued at what time? You have enclosed at page 102,
It's-
4th of June.
Yes, yeah.
What is the time of the email?
101, the time of the email is 3:20, your lordship.
How do you know? Oh, there, on top.
Above, left side, your lordship.
Oh, this is government email. This is 413.
413 is written here, lordship.
Yes, it is 413.
Top.
Then,
Now they say my technical bid is qualified, and the next page they again say that the technical bid has been revoked.
6-4.
5-4, your lordship.
No. No, this 102, why you are mentioning about 413 and all these things? This is an email of 6/4/2021. How are we concerned?
Which page? No, your lordship, it's 4th.
102.
Your lordship, it's 4th June, your lordship. If your lordship
Yeah,
comes,
that I have seen it. What is the time? If you have got this.
the time is not mentioned.
Okay.
The date is
Then-
mentioned, your lordship.
That I've seen it, 4 June.
And
Then
on the
5th
same
June,
day-
what is there?
No, what I want to say, your lordship, on 4th
That
June.
your
they-
bid has been open and updated summary by Iman. Your bid has not been admitted by the committee, and for further information, you are urged to get in touch with the tender inviting committee. Then
Your lordship, on
technical 105. Your name is what?
Soilan Sharma, your lordship.
Soilen Sharma rejected fee pre-qualification technical.
Right, your lordship.
Status updated on 5th of June. Then,
Now, your lordship,
so there are 2 rejected, 2 accepted.
correct, your lordship.
Bhavanath Nath and Minakshi has been accepted.
Right, your lordship.
Then why are you challenging it?
The ground of challenge is that once they have said that my technical bid has been accepted, there
No,
are,
no, not on that. We are not going to go into all these things. Your ground is rejected is scanned technical documents are not attested by the bidder.
Yes,
Did you attest it or not?
yes, your lordship, that is my humble submission. So first,
No, we are only concerned, which is the first requirement of the tender that it has to be attested? And if so, whether you have attested.
Moreover,
Show me the
Lordship,
tender
there
document.
are 2 different hard copies. In the hard copy, Lordship, there are 88 pages, and in the online bid, there is 66 pages. There's lots big difference in the 2 bid documents.
I'll come
Now
to that.
show me that it is required to be attested or not required to be.
Yes, your lordship,
Show me.
it's not required to be attested in the soft copy, but it is required to be attested in the hard copy, which I have.
Obviously, in the soft copy, how can you attest it?
Yes, your lordship.
Yes, yeah, where is it? Bidding document contents. The bidder is expected to examine carefully all the conditions and so the demand bids shall be, which are not substantially responsible able to collect it. Where is it mentioned?
Your lordship will kindly come to page
54,
50, it starts at
page 54.
56, your lordship.
All affidavits should be notarized, photocopies, photocopies, scan copies duly attested by the contractors are to be submitted. Posted copies, scan copies duly attested by the ER. The bidder should furnish his business email, WhatsApp along with the bid, all correspondence. Failure to provide demand will lead to rejection of the bid. So it is on this thing, it has been done, Mr. Council.
Yes, your lordship.
You are there? Mr. Nath?
Not
You are there? The government?
Not-
You have the copy of the petition?
My senior, Mr. B. Goswami, he has made a submission before your lordship.
No, I'm not there. I'm not going to accept that. Now kindly come to page 55. Is that the reason why? One an adjournment on the ground of Advocate General, you have already availed it. Now, if you want to return it and not accept it, I can still take up that series and give you the adjournment. I give you an option. What do you want? There is a adjournment you have
Yes.
taken
Lordship,
where Mr. Das wanted to do it, DK
Correct.
Das.
Lordship.
He still wants to do it. I've not signed the order. I can still take up that matter and adjourn this. Which one do you want? I give you a choice.
No, in that matter, I have no instruction.
Huh?
I have instruction to pray for time. In
No,
the
no,
other-
both
in the
are
other-
same. No? Both are on the ground of Advocate General.
Correct.
So under such circumstances, you want it? I can give you here, but I'll take that.
No, my lord.
Okay, now. Is this the reason why you have done it, page 55?
In fact, my lord, I need
The only reason-
some time to go through the record, my lord, which has.
The only reason why they have cancelled my bid, they have
Is
developed,
that
their-
your document is not attested by you.
they have developed their case by an affidavit every time, your lordship. That's what I want to.
I'm not on that, but that document of why I'm concerned. I'm not on, I won't look under for anything in view of Mohinder Singh Gill's
Yes,
judgment.
your lordship.
I am only going to look into the year at page annexure 9, 104, 106.
Your lordship.
which says not admitted, scanned technical documents are not attested by the bidder. This is the reason why it has been rejected.
Right, your
Now,
lordship.
did you do it?
Your lordship.
First of all, therefore, I asked you whether it was a required as per the thing. Is it page 55 of the petition which says that it is required?
It is required to submit the hard copies to be attested,
Yes.
not the soft copies, which I have done. Now, when I have submitted before this honorable court that I have done that, they come up with the additional plea that some of the documents which are submitted in the soft copy were not submitted in the hard copy, your lordship. That is by an additional affidavit they come.
But are you not required to submit the entire thing?
I have submitted, your lordship. That's what I'm saying.
No, no, no. Is it your case that the bid which you have submitted, that is the soft copy and the hard copy,
Yes, your
are
lordship.
different?
Soft copy not attested, hard copy attested.
Understood, not
I have
necessary.
submitted that way, your lordship.
Understood. No, is it different in a sense that one bid, which is in the soft copy, contains 50 pages, just for example, and the hard copy is 70 pages?
No, in my humble submission, I have categorically stated before this honorable court that I have submitted. I have submitted all the documents.
So you have submitted 70 pages.
Yes, your lordship, all the.
For example,
Yes, yes.
70 pages of soft copy, 70 pages of hard copy.
Right, your lordship.
So in all the 70 pages of hard copy which you have submitted, you have attested it?
Yes, your lordship. In fact, I am required to do so as per 17 and 18 of the clause, which I have done it, your
Where
lordship.
is it?
Page 57, your lordship.
Page?
57 of my writ petition.
Format and signing of the regular, yes.
May I read, your lordship?
Yeah, the bidder shall submit both technical and financial through online one hard copy of the technical bid along with supporting documents as by ITV and clearly marked hard copy of technical bid. In the event of discrepancy between online and manual bid, it will, in the event of discrepancy between online and manual bid, it will be cancelled. The bid should invariably submit the content. Shall bid shall not contain no other addition except those. Yes, read it. Where is the requirement of attestation?
I'm coming, your lordship.
I'm coming in 5 minutes. You search for it.
No, it's,
Bidders are available for online submission for submission through. Scan copy.
Case goes FIR. So therefore, my lord, I do not know on what basis these are the documents, my lord, regarding blacklisting and my lord, that withdrawal of the earnest money. So his tender is no longer there. So I do not know what he is assailing. So as on date, my lord, he is no longer in, a bidder.
Mr. Counsel,
Yes, your lordship.
this EMD was returned to you on 6/6/2021.
Your lordship.
No, listen.
Yes, your lordship.
And you filed the writ petition on 8/6/2021. Have you mentioned that?
No, your lordship.
Then? And how is your petition maintainable then?
Your lordship, in fact, nowhere it has been stated in the affidavit also. It is for the first time it has come up, your lordship. There have been series of affidavit filed by the state, your lordship. Arguments. were made.
Understood, but they have not noticed it. Isn't it necessary for you to come with clean hands?
Exactly, your lordship.
Now, why should this court at present look into a declaration to the effect that any prejudicial action against the so-and-so are writ in the nature of Tertiary to not be impugned so-and-so, scrapping the so-and-so for construction, a writ in a mandamus directing so-and-so from giving effect to so-and-so, a writ in the nature of so-and-so, set aside a writ in a mandamus forbid from giving effect to this, abide by the earlier decision wherein the technical bid of the petitioner was found to be responsible, a writ in the manner directing private respondent so-and-so not to proceed in so-and-so. Then, what is your locus if you are more particularly when you have filed a writ petition on 8/6/2021, that person concerned should know that he had asked for refund and the amount was returned on 6/6/2021 through online mode.
Your Lordship, in fact, as a counsel, for the first time I came to learn this.
Okay.
So, Your Lordship, I may be allowed to take instruction on that point. If that be the case, I'll fairly submit before Your Lordship to pass any order Your Lordship in speak, Your Lordship.
We'll keep it tomorrow. I will record this aspect in my order
Yes, Your Lordship.
and thereby bring it within the ambit of it.
Yes, Your Lordship.
You are only to take, because otherwise that will be amount to suppression of material.
Naturally, Your Lordship, which I would not like to place in that case.
Yes. Heard Mr. R. Sinha, the learned counsel appearing on behalf of the petition. Mr. K. N. Chaudhary, the learned senior counsel,
4 minus 1 number 4.
assisted by Mr.
DJ
DJ Das, appearing on behalf of the respondent number 4. Mr. D. Nath appears on behalf of, which one?
120.
1, 2, and 3.
1.
1, 2, and 3. The learned senior counsel appearing on behalf of the respondents submits that the instant writ petition has been filed by the petitioner, challenging the tender process as well as the award of the tender in favor of the respondent number 4. He submitted that prior to the filing of the writ petition, which was done on 8/6/2021, the petitioner had, upon his request, got the refund of the EMD through online mode on 6/6/2021.
Not on his request, but online, through online. mode.
Through online mode.
Not on request.
The petitioner through online mode have already received, was already refunded the EMD on 6/6/2021. The learned senior counsel therefore submitted that once the petitioner have already received back the EMD and there being no challenge to the same, or there is no mention in the writ petition, it would, the instant writ petition amounts to suppression of material facts. In that regard, the learned senior counsel has placed before this court a detail wherein it has been mentioned that the EMD amount of rupees 8,78,830 was paid through online mode and was refunded on 6/6/2021 through online mode. The learned senior counsel further submitted that prior thereto, on 13/5/2022, he further submitted that on 13/5/2022, the petitioner was also blacklisted by an order by the Chief Engineer, Water Resource Department for illegally withdrawing of the 2% of the earnest money of rupees 9,65,000. This is for some other work.
Some other work.
For some other work. This is, how is it relevant?
He cannot be considered as long as this blacklisting is.
That was never projected by the department.
It was therefore submitted by the learned counsel appearing on behalf, senior counsel appearing on behalf of the respondent number 4, that as the petitioner as of today is blacklisted, the question of the petitioner being considered the relief, if so granted, would not be in public interest. The said documents so submitted is kept on record and marked with the letter X and Y. As the said aspect of the matter is not a part of the pleadings, the learned counsel appearing on behalf of the petitioner seeks an accommodation so that he can take appropriate instructions from his client. Accordingly, let this matter be listed tomorrow at 2 p.m. This court further directs the Water Resource Department to produce the records of the tenders by tomorrow at 2 p.m. Mr. Chaudhary, just wait. Tomorrow, I am keeping that matter, what you call Prasanna Datta,
Yes.
as to be spoken to. Because why I am doing it, as none of you argued on the affidavit which was filed by them in the writ appeal.
Okay.
But I have looked into it.
Yes.
One specific aspect which I will be asking you tomorrow,
My lord.
because I have to formalize it,
Right.
is that there is a Borpeta PS case number
Yes.
43 of 2021.
Yes, yes.
And in that particular affidavit which have been filed, there is a specific allegations to the effect that these are the particular phone numbers.
Yes.
Now, I have looked into it. You just find out what is the charge sheet which has been filed.
In that Borpeta case. My lord.
From the CCTN, as I could find out, he has not been charge sheeted there.
No.
So that will be relevant, but I have to bring it on record by
record.
something. So that is why I'm telling it
I
today.
think,
so
my lord, it
tomorrow-
is only in the context of that Borpeta, my lord, case, I brought out that analogy, my lord. When there is a, my lord, tower nearby,
No,
then
no,
every,
no. You may not have read it properly. What has been given by the SP Borpeta on 5/10/2021. He says that this particular phone number 97060
yes,
923324 was the number which was given by this particular person to your client.
Ah.
And the location of that phone number, as well as the other phone numbers of your client,
those clients,
of your client,
yes,
was the same for the period from 28/2021 20 to 29/2020.
that is the period when in Karimganj that thing happened.
That 1 month. So that is the main reason why it has come in. So
Okay.
you just look into the charge.
Deep.
Otherwise, my judgment was ready. Only but these things has to be regularized. Otherwise, it becomes very
So
difficult.
deal with it since it has come to your lordship notice.
Because when I deliver a judgment, I want that this judgment, if I am delivering in anybody's favor, he can be well protected in the division bench.
Right.
Otherwise, it makes no sense
No,
on a
no,
very
I'll
technical
look into it,
aspect if it is come.
Deep.
Item number 6 to 9.
Yes, so many matters. Why?
Tender of 2021.
Huh?
It is a tender of 2021, my lord.
Then there's a
And the
stake.
tenure was for 2 years. It's regarding supply of dietary articles to the, my lord, various civil hospitals in the state. But I have already, my lord, talked with the director. They will be funding some written instruction to me that they will be going for a fresh tender. Because the term was for 2 years. By now, my lord, it will be over. 2 years will be over, man.
We get an instruction by 2
Yeah,
o'clock.
2, yes.
If you are going, then nothing remains.
Nothing remains.
I appeared for the private party in this case, ma'am.
And the-
We'll see you at 2 also.
Only 1 month left. As per the tender period, only 1.5 months left.
Yeah.
But thereafter, it is extendable for 1 year. If they.
But has the tender been given to anybody?
No, it
No,
cannot-
no,
it was not
it was
technically
challenged at
So
a-
it makes no sense now to keep it. So they,
Technical bit,
tender, we don't have any problem.
technical bit and financial bit, whether technical bit, he challenged his criteria for technical bit was not considered. There was an interim order passed by the court There no financial bill should be opened. It continued for 1.5 hours, 1.5 year, my lord.
So we will pick it up at 2.
At 2.
Before we-
Supplementary list item number 52 from Moson.
Ashok, can you take the matter at 2?
There are other 2 matters also, na?
Yes, that has been listed in courtroom 5.
Okay, it's there. What number? So, this is what?
So this is.
Then why these matters have been listed today? This one is there, the others are there. Why? If it is others are there, the matters should, because I think then it will has to have the same yardstick. Have you got a stay there?
One is for maybe 1 month and other is for 1 year.
One?
One matter is they got stay for 1 month till June, I guess, and the other one is for 1 year.
I'll do one thing. I'll direct the registry to place the matter. Today I won't take it up, then let it be matter be listed before 2. All the registry. Registry matter.
Lordship, he has to relieve tomorrow.
Understood. So that is why I'm asking the registry to come here, so that he listed this matter at 2 before that call, because otherwise there will be conflict.
Yeah, yes, Lordship.
All the registry. I think you, madam, you may have to just find it out, and then I'll request the registry to list it before him, court number 5. Yes, Mr. Yes, Mr. Rahul Dhar. Mr. Rahul Dhar, that matter, no, I was just telling Mr. Chaudhary also. Yeah. Tomorrow I am keeping it for to be spoken to. Because both of you didn't argue anything on that affidavit.
Which one, madam?
The affidavit which you filed before the division bench.
Yes,
Nobody argued.
I tried to, my lord.
No. In that affidavit you have only shown the additional affidavit. And more particularly that record was not here. Then I got told, when I was looking into it, I saw that it is written as additional affidavit. Then I thought that yes, there has to be something. And in the office note, it is mentioned that there is no affidavit. Then I searched out that, because if you see the division bench order,
yes.
no, division bench order says one thing. That a writ appeal which is on affidavit should be treated as a part of the records.
My lord, exactly.
It doesn't say about that affidavit. If you see that order of the appeal in 353, it does not say that. Then I was just finding out there in the division bench thing, there is nothing mentioned in the writ appeal. And the writ appeal was on a certificate. I don't know, how can it be possible? And I was looking into and search and then got hold of that affidavit.
There was an affidavit.
And there is a reply to that affidavit also. So then I thought that it is better. Tomorrow I am keeping it for to be spoken to. Just find out what has happened in the Borpeta PS case number 43 of 2021.
My lord, that CID.
Not the CID.
Borpeta.
Borpeta PS.
My lord.
Because in your affidavit, there is a particular document which have been enclosed as the last document, which was the basis of your review, which was made on 9/2/2021.
Yes, my lord.
22 or 21. 9/12.
9/12.
That particular document categorically shows that there are certain serious allegations against him.
Against him, yes.
And this particular document, when it is being seen, now what has happened to the Borpeta PS case number? It has already been charge sheeted. That I could see from the, nowadays we have this Justice app. We can very well look into it. And it has been now numbered as PRC in 2021 or 22. Early part, they have already been charge sheeted. So just find out what has happened. So, Bhatnatu is the key. There were 3 matters which this court is taking up specifically all transfer matters. Those 2 matters have now been listed before court number 5, which are similar in content to this. So under such circumstances, those 2 matters have been listed. More than a delegate order in going to list this as a production list. The person order to the pass. Taking into account that there were 2 other writ petitions along with the instant writ petitions, which is the subject matter of transfer. And they were similar in content. It has been, however, mentioned by the learned counsel for the petitioner that the other 2 writ petitions have been already was taken by the court number 5 of the Scott, and there has been certain orders being passed. In view of the fact that as the state court have already passed some orders, and any order passed now in this writ petition, and in order to maintain the uniformity, this court directs the registry to list the matter today itself, taking into account that tomorrow is the last date when the petitioner, tomorrow is the consideration of the interim prayer has to be made by today. Do my dear, Mr. Goswami, this matter, there's the other 2 matters, there's some orders being passed.
Orders will pass, and this is before your lordships.
So I'm asking this matter to be listed today before that court. Because one has to maintain uniformity. If I pass some other order, then it may not be uniform, no? Because all 3 matters were almost same.
We expected that all the 3 will be listed in the morning. Those matters are taken up, and it is before your lordship.
That is why I say that let the matter be taken up by that 2 of them.
Highly.
And number 39 for admission. 39.
Okay, none appears on behalf of the. Admission of the issue. None appears on behalf of the councils, either for petitioner or the respondents.
Respondent 1, government is appearing.
Yes, what is your case then?
Your Lordship, our role is very limited here. Higher education and Dibrugarh University has to take the case.
Then you have nothing to say.
Nothing.
As none of the councils appearing on behalf of the petitioner and the respondent is appearing, that the matter be listed after the summer vacation.
Item 40 for hearing.
40, my lord, I appear on behalf of S. Das, my lord. On morning hours, he informed me he had to rush to Delhi for a certain reason, my lord.
So I pray on his behalf for accommodation for today, my lord.
It's been pending since 2011, Lordship, and it relates to a
Post.
small issue.
Yes, tell me. What is the case? You don't get a chance of this hearing being taken place. If none is appearing for the respondent, don't worry.
Well, I don't hold the brief.
Huh?
I don't have the brief with me.
Don't appear.
I
Who has
just-
asked you to appear? If
And
you
his,
don't hold
my
the
lord,
brief, you
my
don't
lord,
have the
leave-
wakalatnama.
my
I'm
lord,
not
leave note is there,
concerned.
my lord. He has
Huh?
a leave note. Leave note is also reflected.
Leave not, let it be there. It is not seen out here whether he has filed a wakalatnama.
Now, he is a standing counsel to the SIDC,
So if he is not appearing, then I'm not concerned.
my lord.
Yes, what is your case?
Lordship, we were not granted the pay scale, Lordship, that we were entitled to.
What pay scale?
Lordship, we,
Of the draftsman?
no, Lordship, of architecture, apprenticeship, Lordship. We passed it from Girls Polytechnic, Lordship. It's a 3 years diploma. We passed it in 1988, Lordship. And subsequently, Lordship, we went for training at ASI DCL, and after 18 months of training, Lordship, we were working as casual employees in ASIDC. Subsequently, Lordship, a resolution was taken by ASIDC, Lordship, that and 4 posts were created, Lordship, against which, Lordship, upon sponsorship from the employment exchange, we were absorbed, Lordship. And
You are absorbed.
absorbed means,
Where is that order?
Lordship, our call, we were called for interview, Lordship.
Where have you been absorbed?
The Lordship, the annexer to page 16, Lordship, is the call letter, Lordship. And
Where is your absorption order?
Lordship, that I have not annexed, but
Then-
Lordship, we have made a statement.
No, statement doesn't matter. After the 2011 matter. If you have made a statement, the statement doesn't make any sense.
That is the admitted position, Lordship, because we were working against that post since.
No, your right has to spring from something. Where is your right? Unless they have admitted in your affidavit that yes, we have absorbed you.
The anomalies with regard to the pay scale, Lordship, we ventilated the grievances before the authorities, Lordship. They said, Lordship, that the post against which we were appointed does not relate to the works which, Lordship, requires a higher pay scale, Lordship. Lordship, the appointment order they had annexed, Lordship, in the affidavit in opposition. Page 12.
Yes, page 32, running page 32, page 3. In this regard, the respondents most respectfully beg to state that the petitioners were absorbed in the service of the year after due process of creation of post, notification of vacancies in such posts to the district so and so, selection through interview, and for such an issue of year. The petitioner joined the corporation agreeing to all the terms of appointment, including the pay scale of Iman and places of posting, as stipulated in clause 5 of article 98 of the memorandum of association of the corporation, is absolutely authorized to fix the salary. Moreover, the petitioner cannot claim a higher pay scale only on the basis of their educational qualification, and the same is not the sole criteria in deciding the pay scale of the particular class. With regard to the amendments that the aforementioned regarding granting of technical allowance as admissible to the members of technical in an engineering department, the respondent makes to state that the corporation has no provision of granting any such technical allowance. Then,
Lordship, we have filed an affidavit in reply, Lordship.
denying that.
Paragraph 8, Lordship, in our petition, Lordship, we have stated one thing, Lordship, that we had approached the Women Commission and the Women Commission required the managing director of ASIDC to pose an inquiry into the matter and whether we were entitled to that pay scale or not. Subsequently, what had happened, Lordship, they constituted a committee to inquire into that, but that committee never furnished the report to the Women Commission, Lordship. In this case itself, in the order dated 7/2/2012, Lordship, this court had required the respondent authorities to furnish the inquiry report, but that never came up. With our contention, Lordship, that the qualification we acquired, whether that was the criteria to be granted the highest pay scale, Lordship, that was to be taken into consideration, Lordship. And
No, this is a corporation after all.
Lordship.
The corporation has to either adopt a particular pay scale or it has to go on as per its memorandum of association. What is your basis to say that you are entitled to a particular pay scale?
Because, Lordship, other similarly situated persons who were engaged against those posts, Lordship, the technical trade, Lordship, they were granted that pay scale from that time itself, Lordship, and we were deprived of that pay scale.
No, are you saying they were granted by the same corporation?
No, Lordship, but in other corporation also, and in this corporation itself, there was a post of draftsman, Lordship, and against that post, one person was appointed, and he was granted higher pay scale for that.
Is your thing same with draftsman?
In fact, Lordship, for the minimum qualification required for the post of draftsman is 2 years diploma, Lordship, and we acquired the 3 years diploma, and along with that, we had pursued 18 months training. But in spite of that, Lordship, we were granted lesser pay scale. That was one of our grievances.
No, Mr. Counsel, don't you think it is a very difficult thing to do without anything being brought on record as regards the ASIDC and all? This ASIDC, na?
Yes, Lord.
Without their articles of association or memorandum of articles being brought on record? How can this court impose upon a corporation something which they categorically say that they won't? They have the power to do so. How this court can give that direction? Because after all, a corporation has to decide, has its own, whatever may be. They have their own rules and regulation, how do they fix the salaries and all. Now, I understand your case is that similar corporations is given same work, it is on the basis of equal pay and equal work. It's been given on something more than that. Which are the persons who have been given more than that?
I'm relying upon one Deposit Sarkar. He was in the same corporation, Lordship. He was appointed as a draftsman, Lordship. Subsequently, he was promoted to the post of engineer, Lordship. And Lordship, when he served as draftsman, Lordship, he was.
And you were regularized as what?
We were regularized as.
What is your status?
Technical assistant, Lordship.
And he was regularized as sub-engineer.
He was subsequently regularized.
So is sub-engineer same with the technical assistant?
They say that, Lordship, both the posts are different now, Lordship. But we were claiming since his appointment, Lordship, he was appointed as draftsman. We were claiming that in the post of draftsman, when he was serving, Lordship, he was getting higher salary than us. In the same capacity, Lordship, in other corporations, Lordship, the post of technical
my lord,
assistant.
I had a brief stint with ASIDC as a standing council, my lord. As far I could recollect, my lord, what are they saying? Since our education qualifications are same, in fact, I have a better qualification, so pay scale should be same, my lord. But education qualification is the criteria for my lord, different pay scales, my lord. That is the case. We are resisting that case. I could recollect, my lord.
No, not only education qualification, it's a question of recruitment also.
Yes, my lord.
If you see the 2018-19 is a Supreme Court judgment, wherein it says that not only it's a case, this is after Jagjit Singh, wherein it says that not only the various parameters have to be looked into, but because you see, Mr. Counsel, kindly look into this. If fixing a pay scale in a particular corporation is absolutely their discretion. Yes, if it is unjustified or discriminatory, this court can very well give it. But this court also has to take note of that if a pay scale higher is given, then in that case, it may also disturb the equilibrium which they have in their particular services. They may think of a particular, therefore, if you see in that particular judgment of 2018-19 SCC, I think Justice Lalit and Justice Sapra's judgment, I suppose. They say that paragraph number 96, it has been mentioned that which are the reasons when you can do so. And then further developed it, that Jagjit Singh did not take into consideration two other aspects of the matter. One is the question of recruitment. There might be some persons maybe having the same qualification, doing the same work, but if the recruitment is made on a different yardstick, then they can't be equated. These are the problems which you are facing here.
For that reason, Lordship, when the matter was referred to the Women Commission, Lordship.
Are you all women?
Yes, Lordship, 4 of them.
And why the Women Commission is there? Is it your thing that the woman is because of being woman? These people have discriminated you.
No, Lordship.
Then why have you gone to the Women
Page
Commission?
21 once, Lordship.
Huh?
Page 21 once, Lordship.
Page 21.
It was yes, Lordship. It was a representation written to the managing director, Lordship, and a copy of that representation was forwarded to the
Worth
president.
mentioning here that one employee of a corporation who joined in the post of draftsman, where the minimum required qualification was 2 years certificate, is now posted as subdivision, which is more justified than that of the apostle colleague have not been considered, thereby deprived us of our legitimate views, putting us in an embarrassing position. It's further to be mentioned here that the state incumbents have been given out of turn promotion in 2007, where a genuine reason was not taken into. Yes.
Paragraph 4, Lordship.
Paragraph 3, the last 3 lines of paragraph number 3.
Not taken into.
That it shall not be out of place to mention here that the resolution passed on Iman, held on Iman. It was decided to appoint 4 technical assistants to 1 supply content on page 10. Last allowed the matter of great concern that while appointing Arjun to supply the we will pay the way up to reach on the above action of the authority created here. We are working so is it your case that being a woman you have been discriminated?
They thought so, Lordship. So they.
No. Is it your case when you are referring to this document? Because this is a document on the basis of which you are saying that being a woman you have been discriminated.
Lordship.
Is it your case?
Because, Lordship, why that came up, Lordship? Because this ASIDC did not have the 4 posts against which we were appointed earlier, Lordship. It was created just prior to our appointment to that post, and that we were continuing as such in that post itself. Now there is no promotional avenue or something like that, Lordship, but then we are serving in that post itself, and we being women, Lordship, only 4 posts are being held by us, Lordship, in ASIDC, and no other candidate is there holding similar post. That's why they might.
No, is it your case that because you are a woman, you have been discriminated? Then it's at another, it goes on a different tangent. Is it your case that, or no?
No, Lordship, exactly that was not what was projected in our readings, Lordship. But then, Lordship, it was one of the Lordship. They approached the Women Commission, Lordship.
Mr. Counsel,
Later, Lordship.
let us make it very simple. I'm asking you a very simple question. Is it your case which you are trying to make out that because you are a woman, you have been discriminated? If that is so, this court will look in that angle.
Lordship, we were simply agreed by non-grant of the higher pay scale.
So you are on that. No, not on the basis that you being a woman, you have been discriminated.
No, Lordship, there is no such reading, Lordship. But then the representations and other things, Lordship, indicates to some extent, Lordship, to that angle also. Lordship, whatever it may be, Lordship, an inquiry was required to be conducted by the KSIDC, Lordship.
And why haven't you made the director of technical education the government, the party?
Director of Technical Education has page 24, Lordship will find, has given a finding that the diploma held by us is similar to the other educational technical.
Reference, I would like to inform you the following few points for your information. It is intended to produce in architecture area who are admission qualification for Armida is same with other.
They have supported our case.
So you should have made these people party, don't you think so?
Since they have supported our case, Lordship.
So you should have made them a party more particularly. Then they would come up with an affidavit and then you could have got the benefit. Something, but if you have not done it, what to do? Assam Diploma Service Engineers. Perhaps you are aware that the fact that the diploma holders in various government enjoying the basic scale of spending.
Page 25, Lordship will find that Director of Technical Education.
What is their stand in the affidavit as regards what stand they have taken as regards the Women's Commission's direction?
Nothing, Lord. At paragraph 8 of my reply, Lordship, I have stated that, Lordship, they have said nothing about this inquiry, Lordship. Subsequently, they filed another affidavit. Therein, they have just stated that the committee was constituted, but due to the retirement of one M. Deuri, Lordship, the meeting could not be held. It was on 3/1/2012, Lordship, one meeting. Affidavit was filed. Paragraph 4 of that.
But educational qualification cannot be. How are you saying that your work and their work is same? That draftsman work is same?
Lordship, same thing we have not.
Because you have been, as have been stated out here in the affidavit,
Lordship.
they categorically say that you are working in some divisional or marketing as marketing division of the branch office at Jorhat and Tejpur.
With regard to Debojit Speaker, they said that he was promoted and he was having different duties. But with regard to that draftsman post, they did not say anything, Lord.
And you have not made picked and choose basis, and in spite of possessing qualification higher than the petitioner were discriminated.
But in my reply, Lordship, in my reply, I have annexed some documents to show that the nature of works done by Debojit Sokia, one who was promoted as engineer.
Are you saying that persons in the Maniram Devan Trade Center, somebody being asked to do up this thing or that thing, would show that equal pay to equal work?
But Lordship, the nature of works they do, Lordship.
You have been
It's
given
of
a
that nature, Lordship. So they will do that work only, Lordship. And
this doesn't show anything.
মানুষ এখন লেখা আছে 14/7/95 এখানে কি 14/7/95 but there is a letter as I remember from of 95 or 96 my lord the basically foundation of the case is that we possess higher qualifications so give us this higher pay nothing more than that.
No, that I've seen it.
Yes, they have represented before the MD also. That is the case.
We do one thing, Mr. Sharma. You can get a relief from this court. So the best way is to dispose it of, directing the authorities to decide on that on the basis of a decision taken to refer to a committee. Then you may get something. That is the only way out.
but to be directed, but if the decision they take is to be done within a stipulated time frame.
Yes, yes. The same decision we take
Because
it.
this matter is being pending since 2011 and
That is what something needs to be done. Otherwise, this court was to dismiss the petition. Technically, if we see the judgments of the Supreme Court, you don't have a case. But if we leave it to the authority may be considerate more.
Lordship, it's doubtful because Lordship, there was one order earlier, Lordship, to pose an inquiry and to make out whether the nature of work and the qualifications of us are adequate for grant of higher pay scale or not. But they did not take any action. It's been pending since.
Therefore, there is a direction of this court.
Lordship, there is a direction of this court to produce the inquiry report.
No.
Lordship.
Very well.
Of that,
I direct them to look into that aspect. I think that is the best way out. Only way out is that. Because allowing this repetition would not be in your interest also, because this is going to go on appeal, which will be set aside because the law is otherwise against you. And not allowing also for 2011, 12 years it has been there, something has to be given. So the best way is put the ball in the court of the authorities. And technically looking into the director of technical education should have been made a party.
since he was in favor of us.
That is why you need it. I don't understand. If a person is in your favor, you need somebody. That is the most important thing. More particularly if you're a civil lawyer, you will understand. The person who is in your favor, and you can show him as a defendant, make him a party. The moment you are making him a performer, his stand becomes a bit, what you call, the effect of the stand of a defendant and a performer defendant is different. These are the trades, arts, and you were not there at the time when the petition was filed. So your wisdom couldn't have been incorporated in the petition. Otherwise, it would have been. So, okay. Heard Mr. MP Sharma, the learned counsel appearing on behalf of the petitioner. Mr. D. Gogoi appears on behalf of the respondent number 1 and 2. The case of the petitioners herein is that the petitioners were absorbed in the respondent number 1 corporation and in the post of technical assistance. In the construction and technical services and marketing division. This aspect of the matter can be seen from the affidavit in opposition filed by the respondent managing director. Filed by the manager in charge administration of the respondent number 1 corporation. It further appears on records that the petitioner from time to time submitted representations for the purpose of granting them higher scale of pay of rupees 620-1375 and 1375-3375 from the scale of pay of 560-1035, which the petitioners were enjoying. Pursuant to various representations, as nothing worked out, the petitioners also approached the Assam State Commission for Women it further appears that the general manager of the respondent number 1 corporation have also, it further appears that the general manager of the respondent number 1 corporation had also the managing director of the respondent number 1 corporation had also issued a communication on 31/7/2009 had informed the member secretary of the Assam State Commission for Women that the complaint raised by the petitioners as we claim of the claim of the petitioners for higher scale of pay in commensuration with their academic qualification has been taken up for re-examination under the administrative norms of the corporation. It was also mentioned that the claim of the said officials were discussed in the last 2 meetings of the board of directors of the corporation. And as per the direction of the board, the matter has been referred to the legal counsel of the corporation for his opinion. It was also mentioned that action on the matter would be taken after receipt of the opinion of the standing counsel and after keeping in consideration of all aspects of the matter in the overall interest of the corporation. Be that as it may, it is the stand of the petitioner that the respondent number 1 corporation thereupon did not follow it up with the Assam State Commission for Women, and the petitioners were not granted the benefits of higher scale of pay. It is also the petitioner's case that on 22/1/2009, the Director of Technical Education had informed the General Manager of the respondent number 1 corporation about the intention to produce diploma holders in architectural assistancy who are required in the PWD, irrigation and other government technical department, and also public and private sector consulting and contracting organization. It was also mentioned that the admission qualification for architectural assistancy is same with other diploma course under the directorate. And duration is also the same with other diploma courses. Further to that, it was also mentioned that all these courses are approved by the AICTE. It is therefore the case of the petitioner that, taking into account that the petitioners have diploma with 3 years in architectural assistancy, the petitioners are therefore entitled to equal pay for equal work with the corresponding employees of the other corporations as per their qualifications of diploma with 3 years. The Learning Council for the petitioner, the petitioners have also tried to bring out a case of discrimination by making a reference to a person, namely Debojit Saikia, who initially joined in the post of draftsman. And was given the scale of pay of rupees 1375 to 3375. Draftsman who had a given scale of pay, draftsman, wherein the minimum qualification required was diploma with 2 years. Subsequent thereto, the said person have been promoted, regularized, and regularized as a sub-engineer, and granted the pay scale of rupees 1375 to 3375. It is therefore the case of the petitioner herein that a person who has lesser educational qualification than that of the petitioners have been granted a higher scale of pay than the petitioners. And there is also no promotional aspects from the post of the technical assistant wherein the petitioners were absorbed. It is therefore the instant writ petition was filed more than a decade back. Claiming the grant of higher scale of pay to the petitioners which is receivable for posts carrying the minimum educational qualifications of diploma in any technical trade. Semicolon, for a direction to the respondent authorities to fix the pay of the petitioners in the scale of pay of rupees 620-1315, and thereafter to fix the pay of the petitioners at the appropriate stages of the revised scale of pay of 1375-3375 and 3580 to 8,780, and release to the petitioner the areas of pay and allowances. It appears on record that the ASIDC, that is the respondent number 1, had filed a detailed affidavit denying the case of the petitioners. In paragraph number 5, it has been mentioned that the question of granting the technical allowances as admissible to the members of technical service in an engineering department cannot be granted in view of the fact that there is no provision of granting any technical allowance to any member of its employees in the technical service. As regards the discrimination so alleged in the petition, insofar as the employee Sri Debojit Soikia is concerned, it was mentioned in paragraph number 7 that as the draftsman, that Sri Debojit Soikia worked as a draftsman in the corporation from 2/6/1990 to 31/1/2006 in the pay scale of rupees 560-1035. Thereupon, the management of the respondent number 1, in pursuance to its decision of the Board of Directors of the corporation, dated 28/1/2000 and 7/2/2011, regularized him as sub-engineer in the pay scale of rupees 3580-8750 with effect from 1/12/2007 by the order dated 28/2/2011. It is therefore the specific extent of the respondent state, the respondent corporation, that the said employee was not given higher scale of post in the original post of draftsman, and therefore the contention of the petitioner that they have been granted a much lower pay scale in clear violation of the mandate of equal pay for equal work in relation to that employee has no foundation. It was further mentioned that the petitioners were holding the post of technical assistance and are posted at marketing divisions where works of architectural assistance are not available, and they are simply performing other official duties. And as such, the question of seeking parity with other technical assistants, with other diploma holders, has no legs to stand. We'll pick it up. We'll do it. We'll take it up. We'll dictate this and finish up, then take up the other matters. It further appears that an additional affidavit in reply was filed by the petitioner. Stating inter alia that the claim as made by the petitioner for being authorized for being entitled to the diploma scale of pay was not only the ground of diploma qualification, but also on the ground that they were discharging duties similar in nature, status and responsibilities as were being discharged by other persons possessing diploma qualifications and working in the corporation. It was further mentioned that the technical allowance claimed by the petitioners is legally receivable by them on account of their nature of duties required to be discharged by them. In that regard, by bringing on record the various orders of the communications dated 25/8/2008, 23/12/2008, 16/2/2009, 5/12/2009, and 23/9/2010, the petitioners tried to demonstrate that they are also discharging the similar nature work, discharging works of similar nature, status, responsibilities, which are evident from such orders of the communications. It was further stated in the affidavit in reply that in the communication dated 31/8/2009 encloses Annexure 13 to the petition, the respondent corporation had undertaken before the State Commission for Women that the grievances of the petitioner would be redressed on receipt of an opinion from the Standing Council. But no such steps were being taken. And now they cannot be allowed to retract from their stand which have been taken in the communication dated 31/8/2009. I've heard the learned counsels for the parties and perused the materials on record. The question as to whether the petitioners working as a technical assistant with the qualifications would be entitled to pay parity on the basis of equal pay for equal work. With officers, with employees in other corporations, or even the respondent corporation. Would require certain verification of facts as regards the nature of responsibilities, duties, status, which the petitioners discharge as technical assistance with that of their counterparts in other corporations. Mr. Barbujari, that judgment you relied on, that day 2018-19 SCC, what was that?
My lord,
On equal pay, equal work, that one, that.
Yes, my lord, 2019-18 SCC 301, Bihar Secondary Teachers Struggle Committee.
1918 SCC.
My lord, page 301.
Para 96, no?
My lord, my lord. Struggle Committee.
Last time to clear. Require verification. With that of the counterparts in the other corporations, as well as persons working in the same corporation. In the case of the state of Bihar versus Bihar Secondary Teachers Struggle Committee reported in 2018, 1918 SCC 310. 310, no?
301.
301. The Supreme Court, upon an analysis of, after making a copious detail as regards the law laid down in the case of equal pay and equal work, culled out the following propositions in paragraph number 96 of the said judgment, which is reproduced herein under. From the above quoted paragraph of the said judgment, it would be apparent that there are various parameters in which the question of equal pay to equal work for equal work is to be adjudged. The same has to be looked into on the basis of the various dimensions in respect to the jobs done. With the counterparts. Therefore, it was the opinion of the Supreme Court that it is that such applicability of the principle of equal pay for equal work must be left to be evaluated and determined by an expert body. The Supreme Court further observed that granting of pay scales being a purely executive function and hence the court should not lightly interfere, inasmuch as it may have a cascading effect, creating all kinds of problems for the government and the authorities. Another very relevant aspect which was duly noted in the above quoted paragraph, that while entertaining and accepting the claim on the basis of equal pay for equal work, the court must consider the factors like the source and the mode of appointment of the recruitment. Next. In the backdrop of the above, taking into account the facts involved, wherein the question as to whether the petitioners are discharging duties similar in nature, status, and responsibilities as discharged by persons possessing diploma qualifications and working in the other corporations or even in the respondent corporation. Is an aspect which needs to be considered by the respondent corporation. And the same can only be done on basis of subject to certain verifications. Though the petitioners herein have produced certain orders, communications to show that the nature of duties, responsibilities, and status of the petitioners are similar to that of the sub-engineer in question, who is earning a higher scale of pay. But this court is of the opinion that the same would not be sufficient for this court to interfere or pass a writ in the nature of mandamus directing the respondent authorities to grant the higher scale of pay to the petitioners. Be that as it may, this court also is of the opinion that the petitioners' grievances for consideration of a higher scale of pay on the basis of the facts alleged in the writ petition constitutes a legitimate expectation for consideration of their case. Considering the above, this court therefore disposes of the instant writ petition with a direction upon the respondent number 1 to consider the case of the petitioners as to whether the petitioners would be entitled to the pay parity on the doctrine of equal pay for equal work with that of the counterparts in other corresponding corporations of the government of Assam, as well as in the respondent corporation itself. The petitioners, the said exercise be completed within a period of 3 months.
3 months.
the said exercise be completed within a period of 3 months from the date of service of certified copy of the instant order, instant judgment to the respondent number 1, 2. The petitioners are given the liberty to produce such further materials, such additional materials to prove that they are entitled to, on the basis of the doctrine of equal pay for equal work, with the counterparts of the other organizations, other corporations of the government of Assam, as well as also the respondent corporation. With the above observations and directions, the petition stands disposed. That is the most
I'm being item number 1.
Yes, Mr.
Lordship, I have placed 2 documents before my lord. My lord, now the government of Assam, my lord, in cases of land acquisition under the 1964 Act, my lord, the procedure is followed, that is, my lord, called out in the 1964 Act, but the quantum of compensation, land acquisition compensation, that is given as per the, my lord, provisions of 2013 Act, the formula deduced in 2013 Act. That is, my lord, by my lord communication dated 8th of May 2015. Thereafter, my lord, lordship is pleased to take up the second document. That is a notification of 7th April 2022. Here, my lord, the deputy commissioner of all the districts of Assam, my lord, have been clothed with the power of the appropriate government, meaning thereby, my lord, the power, my lord, of the state government in matters of land acquisition have been delegated to the deputy commissioner for the purpose of speedy disposal of the cases. Here, my lord, in the morning, my lord, my colleague and
I don't understand. I'm not on those, but strictly speaking, this what you have done is a very serious thing. You see, you are equating the authority of a collector with that of the appropriate government, meaning thereby Section 19, Section 11 is to be done by the Deputy Commissioner. Section 15, which categorically mentions that this, which is parameter with Section 5, or the recognition which is to be given that the appropriate government shall accept the declaration which is to be made under Section 19 to that of the Deputy Commissioner, who is going to issue that particular or make that particular thing to the government for the purpose of recognizing that this is being done in public interest.
my lord.
Not on that, but
But
don't you
yes,
think
my
that this is a very serious thing which you have done?
no, my lord, because
You can't equate the office of the Deputy Commissioner to that of the appropriate government, because it will have far-reaching consequences. You are making that Section 19 useless.
Yeah.
The person who is going to send it, saying that it is in public interest, he is going to decide that yes, it is in public interest.
yes,
Isn't it a very serious thing which you have done? Thereby you are rendering the power which has been given specifically to the state government or the appropriate government nothing, useless. There's a check, these are checks and balances why
Yes.
the appropriate authority has been made to him and not to the deputy commissioner.
Yes.
So that there is the deputy commissioner, if he does something, the appropriate government can look into.
Yes, my lord, the whole idea is, my lord, if the 2013 Act is pressed into, my lord, service, and my lord, it's a long drawn procedure. In order to avoid that, my lord, because 1964 Act, my lord, is plain and simple procedure. My lord, there is only 3 stages. First is ever acquisition, compensation, award. Now, 2013 Act, my lord, prescribed for a detailed procedure. Impact assessment study, social impact assessment study, everything is there. Now, ultimately, at the end of the day, the amount of compensation that the person's interest.
Now, who is going to do that social impact assessment, which is to be required to be done? The person will be doing it under the guidance of the deputy commissioner.
Deputy Commissioner, yes,
It will be accepted under section 16 by the appropriate government. That is the deputy commissioner.
that is the Deputy Commissioner.
Are you not making the provisions of the act useless? I'm not on that. That is a different aspect of the matter. One day, if it comes before this court will explain.
My lord will examine, but here, my lord, for PD disposal.
Well, but
of,
you
my
can't
lord,
have a speedy. They were making that
no,
act.
I
When there was a
yes,
specific, there was a this very aspect of the matter. They tried to do it by way of a amendment, bringing an ordinance to the effect which was nullified. It couldn't be brought. They brought an ordinance that after the central act.
Yes.
Then,
246
by way of a rule, can you make him an
Yeah, yeah.
appropriate authority?
246 will come into play immediately.
This is on the contrary to 254.
Yes. Now, my lord, here.
Anyways, we are not on that.
Here, my lord, lordship has seen, my lord, the section 6, my lord, publication.
So it vests. The moment it vests, you have to pass an award.
Yes.
When are you passing the award?
That my colleague will be able to.
No, why is he? Who is the revenue?
Well, I am the revenue. My lord,
The
I
revenue
have-
has to
yes,
do it.
Yes,
He's
yes.
the PWD. Is he not the PWD?
No, he is appearing for the deputy
The
commissioner
DC.
because I have been coordinating with the department. Now the department, my lord, says that.
And who is appearing for the PWD?
I will.
Oh, he is now appearing.
My lord.
2 hours before he was appeared.
So, my lord, there is no difficulty to that, my lord. Only
There is the same is assimilation which we see it in the notification dated 7/4/2022.
No, my lord.
Then the assimilation of the deputy commissioner with that of the appropriate government. Here the assimilation with the council. Yes. Yes. When are you passing that award?
Look, Lordship, I have handed over the copy.
Yes. Which one? Many copies are here.
The first is the 10th of December 2021. Next is Lordship will find Form 7.
There are many 10th of December 2021. 1, 2, 3, 4, 5 dates. Which one? All are 10th of December. First to the Joint Secretary to the Government of Assam Revenue Disaster Management.
Correct.
Then again by the Deputy Commissioner.
The next page of that later.
Which one? Yes, to me. Then there is a speaking order.
No, that was sent to the Revenue Department.
Okay, not we
That
are
one
not
of the-
concerned.
from the
with
Revenue
that. The
Department.
next page is here. This is also speaking order, not necessary. Okay. Which I have the honor to the paper publication of Form D of so and so in connection with the acquisition of land of so and so. This is for your ear.
This is paper publication.
Then this is the paper publication. Then
The other one. Lordship may take up the other one.
not this one.
Not this.
Yes, which one?
10th of December again.
Yes, all are 10th of December. That is the problem. 1, 2, you, I am giving it to you. Just give me which one. There are 5 10th of December one. You can grade your which one he wants to play. All are 10th of December. All by the Deputy Commissioner. All to the Joint Secretary. Yes.
Second page of this letter, my lord, this was forwarded to the joint secretary. The next page, my lord, form 7, amount they have shown in the form, my lord. And then the next to that page is the approval by the department.
The next one.
Yes.
Next one is which one? 51,000. Oh,
Form 7, it continues, it consists of 2 pages.
yes, 2 page. The
Two
next
pages.
page is by the collector.
Yes, my lord. Collector, and then below, under Secretary Revenue Department, he has signed
Okay.
on 22nd of,
So this amount is there. So
Yes,
it
sir.
has already been given.
no, this has been approved by the authority.
So you
for
have to pass
for
the award.
Lordship.
What is your problem in passing the award? You pass the order,
Lord-
the award, then he takes up the action under, because I can't direct you just for payment of the money. Without the award, if I direct it, he loses his opportunity under 12.
Lordship, my instruction from the Deputy Commissioner, he said that award has been passed. So this is the approval. Next page, my lord, they have shown the last page, my lord,
This is only for the purpose of this one,
the award, the rent, my lord,
rent.
rent. So this amount he has already, my lord, fixed, my lord, and
No,
this
this
is approved.
is a different thing. This has nothing to do with the award.
Lordship.
This amount, you see, although our courts have passed many orders to the effect that you give both of it, this is a thing which is completely different. This is a requisition. This is under section 3.
Three.
The other is under section 6, read with section 9.
Yes, my lord.
So you have to pass the award
Lordship.
of 17 lakh.
Lordship.
When are you passing it?
Quantum was revised. The quantum of compensation as admitted by the respondent number 2 in his affidavit. That is apparent on the annexure, page 146. That is, a quantum has been revised. It has been enhanced to 30 lakhs 2,731 under the new act. Since that is not, your lordship may kindly come to page number 146 of the affidavit. It is a large one of affidavit submitted by them. Come on. Please. Last paragraph.
Just 1 minute. Huh? Yes, show me where.
My lord, at page 146 of the affidavit submitted by the respondent number 2, Deputy Commissioner. This affidavit was submitted in pursuance of an order passed by this honorable court. As per
Page 1
page 146, my lord.
of
Annexure
which affidavit?
94.
There are many affidavits are there.
Affidavit
This is
filed by the
the-
respondent number 2, Deputy Commissioner.
Respondent number 2.
Is by respondent number 1, there is an affidavit.
Respondent number 2 of this affidavit.
When did the affidavit was filed?
It was filed in the
The
September
affidavit of respondent number 2.
2021.
Got it, got it, got it. This is a joint register to the High Court. No, there is only 2 lines, additional affidavit. By Mitali Lokar.
No, by
No,
Mrigesh Narayan Borua.
The large month
It's a voluminous consisting of many annexures.
yes, my lord. Total number of pages is
146.
147.
147.
And my lord, I'm referring to the last page, 147.
Just 1 minute.
Type
Just
copy
1
is
minute.
available at
146.
page 147.
Yes.
My lord, lordship may kindly come to the last paragraph.
Hmm.
Later on, a meeting was held on 18/1/2020. As per decision taken in the meeting, revised LA estimate against LA case number 290-91 arising out of WPC number so and so, Jagadesh Soikia and State of Assam and others amounting to rupees 30 lakhs 2007-31. This was the revised quantum under the new law. my lord.
No. Mr. Counsel, you give it to him, this one.
Yes.
That was filed earlier, probably.
Whatever means. You see, that was a submission and that was a proposal submitted.
Yes, sir.
If you are agreed, you can very well take it up under 12. You see, these things needs to be formalized. If you have anything, you can. That is why I'm saying, under section 12, you have a right to assail that yes, that the amount is less. You can vary. That is why I'm saying that let them pass the award. Then you can take the action under 12. Now, as of now, they are saying 17 lakhs. Let them get it, pay it to you, which is the relevant consideration. Now, if you see this particular document, you see this. Now, as for the new act, Mr. Counsel, from section 26 to 2030 stipulates the manner in which the competition is to be made. As per section 26 and more particularly 27, it says it shall be on the purpose of the value of the land. Value of the land can be computed under three circumstances. There might be an agreement for sale, there might be a sale deed, or whatever may be, they will look into it. That is one. Number two is, if more particularly, if you see section 26(2), if there is a question of it is in the rural areas, then it has to be on the basis of a multiplication factor, which is given in Schedule 1. Now, in Assam, there is a multiplication factor that if it is outside the particular 5 kilometers area or area, the multiplication factor shall be 2. Now, you see this particular document at page 227, the second page. The value of the proper land has been taken in 1,48,000. Okay. Then you see the multiplication has been done by 2. This is done under 26(2). So this is there. Then as per section 27 and 28, you will find the GRAT value. So this is how they have taken number 4. Now you see as per section 30, it categorically says that there will be 100% as the solution. So this is how they added 7,51,000 to 7,51,000. This is 100. And therefore, another additional compensation of 12%, which they are saying, which is required under 33. It categorically says that it should be from the date of the notification to the date of the award. Now, obviously, this will change because as of now, the award has not been passed. So therefore, you'll be entitled for that. This 12%, which will increase. But for that, if you have this new act, or the old Act 64 Act, you have to move on the section 12. So you do that. But first you get this.
Yes, award.
Yes. Anything else?
No, nothing. What he has been indicating in the affidavit, that has been taken care of by the Honorable Court in the last order, which
Not
was
necessary. Those, you see, matter is simple. Don't you think, Mr. Borbojari?
Correct.
Isn't it a simple matter?
Yes,
I don't understand what is the complication for a matter to be pending for 2014.
Correct.
Everything as an out of the fact, my lord, at the 11 point of time, the authorities did not pass that award. Had that award been passed, this
Matter would have been
matter
ended.
No, award would have been passed. He has a right under section 12. Whatever he wants to do, let him do it. But for that, you have to accrue that right for him.
Logic.
And he doesn't have the right till you pass the award.
Absolutely.
Logic.
It is only because of that reason, my lord, this is the very foundation of the repetition.
Huh?
This is the
that
very
is the-
foundation of the repetition.
Yes. Unless I am missing something, which both of you have not been pointing it out.
No, my lord, it is our fault. We have to be, my lord, very fair. It is absolutely our fault. I had to, for which, my lord, he is gaining more money as on today. If the award would have been passed, my lord, at the 11 point of time, my lord, way back in the year 91, 92, my amount would have been, my lord, hardly, my lord, at the most, my lord, 2,50,000. Around 2 lakhs. Around 2 lakhs. Now he is getting 17 lakhs. Apart from that additional amount of rupees 55,000 and odd amount, my lord, towards requisition.
Heard Mr. R. Sharma, the learned counsel for the petitioner. Mr. R. Borpujari appears for the Revenue and Disaster Management Department. Mr. D. Nath appears on behalf of the respondents numbers 2 to 5, and Mr. R. Dhar appears on behalf of the PWD department. That is the respondent number 6 to 8. The instant writ petition, taking into account the pleadings being complete and the materials available on record, this court has taken up the instant writ petition for disposal at this stage. It's an admission or hearing.
It was petition hearing.
Okay, takes up the matter for disposal at this stage. The case of the petitioner herein is that petitioner is the absolute owner of a plot of land measuring 12 bighas covered by Dag number 121 of Patta number 7 of Revenue Village number 2, Herigao under Moza Borpatha, Revenue Circle Horupathar subdivision Dhansiri in the district of Golaghat. It is the case of the petitioner that out of the 12 bighas of land, measuring 5 bighas, 2 kathas, 3 lechas, with well grown up healthy bushes, producing best quality, 1894 best quality along with well built up drainage system, developed roads, fencing and other valuable trees have been acquired by the government of Assam for and in connection with the development of the construction of Kusal Kuar Setu over the Dayang River, that is for converting the road of Jamuguri Dhans Dhasam. It is the further case of the petitioner that the petitioner also had another plot of land measuring 7 bighas, 3 kathas, 19 lechas, covered by Tozi Patta number 81 of Revenue Village number 2, Tamuli Gaon, under Moza Borpathar, Revenue Circle, Horupathar, in the district of Golaghat, Assam. In the said land, the said plot of land was purchased and occupied by the petitioner, was later on given by him to his eldest son, Gautam Saikya, since deceased. During the lifetime of his eldest son, he started a small tea garden under the name and style of Dayang Seo's Mini Tea Garden, with due recommendation from the Small Tea Growers Advisory Program, Assam Agricultural University, Jorhat. A portion whereof, measuring about 3 bighas, was also acquired by the government under the land acquisition case number 2/1990-91. by taking over possession thereof from the son of the petitioner in connection with the development of the construction of the said Kusal Kumar Hetu over Dayang River. In consequence to the said acquisition so made by the government, it is the case of the petitioner that thousands of well-grown healthy tea bushes were damaged and uprooted, along with other trees and properties, as could be seen from the common Jirat list prepared by the then Circle Officer Horupatha Revenue Circle. Assam kon nalage. It, however, appears that though the LA case number 2/1990/1990-91 was initiated but in view of not issuing the declaration under Section 6 of the Land Acquisition Act 1894, the said proceedings lapsed. However, the land which was acquired from the petitioner, however, the land which was, the possession of which was taken over by the authorities concerned, continued to remain with the authorities. It is under such circumstances the instant writ petition has been filed claiming compensation for the loss and damages suffered by the petitioner and his deceased son on account of the possession being taken over in respect to LA case number 2/1990/91, on the basis of fresh assessment to be made in the light of the judgment and order dated 28/6/1996 passed in division bench of this court in MAP number 106/1992, together with other costs and charges payable under the Land Acquisition Act. Strictly speaking, Mr. Counsel, your case comes under Section 28A of the Land Acquisition Act, not these provisions. Anyways. Be that as it may, it is relevant to take note of, from a perusal of the writ petition, as well as the documents enclosed to the instant writ, as well as the affidavit, the pleadings exchanged between the parties, that a plot of land measuring 1 bigha 4 katha 5 lechas belonging to the petitioner was taken over by the respondent authorities for the purpose of construction of the Kusol Kuwar Khetu over Doyang River. That is for converting the road of Jamuguri Dhondesok. There has been no award so passed pursuant to the lapse of the proceedings under LA case number 2/1990-91. But the responding authorities in the PWD department continued to use the said land. It therefore appears that the case of the petitioner hinges upon the inaction of the responding authorities, more particularly the Revenue Department, in taking over the land of the petitioner without following the due process, thereby violating the mandate of Article 300A of the Constitution of India. It further appears from the various orders being passed by this court that the responding authorities, more particularly the Deputy Commissioner, which one? Golagat. Having taken certain steps for the purpose of acquisition of the land. Where is that paper? You have given it to me, you have returned it back. Those notifications under section 6. It appears that in pursuance to the orders passed by this court, acquisition proceedings under the Assam Land Requisition and Acquisition Act 1964 has been initiated insofar as the land measuring 1 bighah 4 katha 5 lechas in village number 2 Heri Moza Borpatha, which was used for the purpose of construction of the RCC bridge over the river Doyong at Dhondharshyam Ali in Jamuguri Ghat. During the course of the hearing, the learned senior government advocate, Mr. D. Nath, have placed on record that in terms with section 6 of the said Act of 1960, said Act of 1964, notifications have been issued. A notification has been issued, which was subsequently published in the Assam Tribune on 10/12/2021 under section 6 of the Act of 1964. However, it is also the stand taken by the respondent herein that till date, the award which is required to be passed on the section 11(3) of the Act of 1964 has not yet been passed. At this stage, upon the said documents pertaining to the section 6 notification is kept on record and marked with the letter X. It further appears from the materials further appears that on 10th of December 2021, the Deputy Commissioner Golaghat had also placed the proposal before the Joint Secretary to the Government of Assam Revenue and Disaster Management LR Department, stating inter alia that the amount of compensation in respect to the land measuring 1 bigha 4 katha 5 lechas have been determined. And upon determination, it has been found that the total amount to which the petitioner would be entitled to would be rupees 17,49,686. No, it will be less, na? The total amount as regards the compensation have been determined. On the basis of the communication, on the basis of the communication dated 8/5/2015, issued by the Additional Chief Secretary to the Government of Assam, as per the provisions of the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013. For short, the Act of 2013. As per the said competition determination so made, the total amount of compensation to which the petitioner would be entitled to would be rupees 15,20,460. And an additional amount of rupees 2,28,069 shall be the administrative cost to which the office of the Deputy Commissioner would be entitled to. During the course of the hearing, the learned senior government advocate had placed on record the manner in which the amount was determined, and the government and the revenue department of the government of Assam have also approved the same. The said document so placed is kept on record and marked with the letter Y. It is also relevant herein to mention that on the basis of the orders passed by this court, the period from 1990 on the basis of the orders passed by this court in the instant writ proceedings, it has been also computed and determined that the petitioner would be entitled to an amount of rupees 51,529.88 on account of requisition costs for the period from 1/1/2004 to 30/12/2021. This court, however, finds it relevant to take note of that while in the computation it has been mentioned that it has been done in terms with the Act of 2013. But the interest at the rate of 12% in terms with section 33 of the Act of 2013 stipulates that the entitlement of the interests would be at the rate of 12% from the date of the notification under section 11 of the Act of 2013, which would be corresponding to the notification under section 6 of the Act of 64. As it is an admitted case, that till date no award has been passed. Therefore, the computation of the interest has to be calculated on the basis thereof. Computation of the interest has to be calculated on the basis from the date of the notification under section 6 till the date of the award. This aspect of the matter, the petitioner can very well take while filing an application under section 12 of the Act of 1964. I've heard the learned counsels for the parties and have perused the materials on record. It appears from section 6 of the Act of 1964 that with upon the issuance of the notification under the said provision, the land absolutely vests upon the state. Therefore, the land measuring 1 biga 4 kata 5 lechas in respect to LA case number 1/2021-222 stood vested upon the state on the date of with effect from 10/12/2021. No. With effect from 22/11/2021. That is the date on which the Joint Secretary to the Government of Assam Revenue Department had signed on the notice under section 6. In fact, this aspect, earlier I was always under the impression that it will be from the date on which it was the final publication. Then there is one judgment of Justice M.B. Shah, I think 2022 or 12, 7 SCC. The question arose out there that it has to be within 1 year. as to whether 1 year will be from the date of publication, from one day till the date of publication in the paper. He said no. For the purpose of section 4, it will be the last date of publication, but for the purpose of section 6, the date the government signed.
Yes, because the decision is to be taken into account, the decision of the government.
Yeah. So it will be that date.
Yes, absolutely.
However, the Act of 1964 stipulates the formalities to be, the stipulates certain procedures as animated out there in paragraph number, in section 7. Nine. The effect from will vested upon the state. In terms with section 6 of the Act, on the date when a notice is published as required under section 6 is published in the official gazette, the requisitioned land and premises shall, on and from the beginning of the day on which the notice is so published, vest absolutely in the state government, free from all encumbrances, and the period of requisition of such land shall end. When did you publish in the government gazette? It further transpires that on 22/11/2021, the Joint Secretary to the Government of Assam Revenue Departments issued the notice under section 6 of the Act of 1964. It further appears on the very date the Joint Secretary to the Government of Assam have issued communication to the Deputy Commissioner Golaghat, copies to the Director of Printing and Stationery, Assam Government, for publishing of the substance of the notification issued on 22/11/2021. Within a week's time in the Assam Gazette, the Learned Counsel appeared, senior government advocate appearing on behalf of the Learned Senior Government Advocate submits that in pursuance to the said communication, the publication had been duly done in the official Assam Gazette He further submitted that on 10/12/2021, the notice under section 11(6) was published in the Assam Tribune and the Assamese one also. What is that?
Newspaper, मतलब, possibly this is Dainik Janambhumi or like that.
You just inquire and comment.
I can answer.
And the Assamese vernacular and the vernacular daily.
Dainik Janambhumi possibly. I'll just verify.
Namely, he will give you that.
Yes.
Therefore, in terms with section 6(2) of the Act of 1964, the land which was requisitioned, which was kept on requisition, ended, and the land stood vested upon the state, free from all encumbrances. It further appears from the Act of 1964 that section 11 of the Act of the said Act stipulates about the compensation. Section 11(3) of the Act of 1964 stipulates that when the compensation has been determined under subsection 1 or subsection 2, the collector shall make an award in accordance with the principles set out in section 11 of the Land Acquisition Act 1894. Subsection 4 of section 11 further stipulates that when any land was requisitioned under section 3, there shall be paid subject to the provisions of subsection 5 to every person interested such compensation as may be agreed upon in writing between such person and the collector, or in the absence of an agreement, reasonable compensation in respect of the requisition of such land and the damage done during the period of requisition of such land other than what has been sustained by the reasonable wear and tear and irresistible force. Admittedly, as of now, there has been no award passed in terms with section 11(3) of the Act of 1964. Which is the mandate of law to do so. At this stage, this court further finds it relevant to take note of a notification take note of the circular issued by the government of Assam in the Revenue and Disaster Management Department, wherein it says that the landowners would be entitled to the compensation in terms with the Act of 2013. Ek kaun sa? Further to that, apart from that, it is also relevant to take note of that as per section 11.3 of the Act of 1964, it has been mentioned that the collector shall make an award in accordance with the principles set out in section 11 of the Land Acquisition Act 1894. Both the Act of 1894 as well as the Act of 2013 stipulates the passing of an award within a stipulated period of time. Else, there would be payment of interest from the date of the notifications till the date of the award at the rate of 12% per annum. Under such circumstances, this court is of the view that payment of interest payment of the award and the passing of the award, the delayed passing of the award has the effect of payment of additional interest, which in turn affects the public interest, the public exchequer. Considering the above, this court therefore directs the Deputy Commissioner Golaghat to forthwith pass the award and not later than 15 days from the date of passing of the instant judgment. It is further seen from the provisions of section 34 It is also relevant to take note of. That pursuant to the passing of the award, and the position being taken, the interest as per the Act of 1894 as well as the Act of 2013 is 9% for the first year and 15% after the completion of the first year. In the instant case, as the possession has already been taken, any delayed payment of the awarded sum would further incur additional burden upon the public exchequer. And as such, this court further directs the Deputy Commissioner Golaghat to pay the said amount within a period of 15 days from the date of passing of the award. This court further makes it clear that if the said amount is not paid and the state is liable to pay additional interest, the same shall be recovered by the state from the salaries of the erring officials. During the course of the arguments, the learned counsel for the petitioner further submitted that the amount of rupees 15 lakhs $20,460, which have been computed, determined, is not as per the provisions of the Act of 2013. He submitted that the same has been done so without taking into account the parameters of Section 26 as well as 27 and 28 in the proper perspective. The said submission is duly noted, but this court, taking into account that there is a provision of filing a reference in terms with Section 12 of the Act of 1964, grants the liberty to the petitioner to take such action, to take such action if so advised, under the provisions of the Act of 1964. With the above, the petition stands. Copies of the incident, the judgment comes into effect today itself. Huh?
Yes, well, no difficulty. My lordship has directed, given a leeway of 15 days to publish the award. My lord will also direct, my lord, since the PWD is the beneficiary. What has happened, my lord, in the at the relevant point of time when that at the earlier point of time when that land acquisition proceedings were drawn up. It is only because of, my lord, default on the part of the PWD that
Mr. Barbujari, I have not said the erring officials of the revenue or the delay is between all of you. So whenever you find out, yes, the delay is because of Mr. Dhar, get hold of it and collect him.
no, because why I am making this submission, because lordship has issued the directions, my lord, particularly to the deputy commissioner.
Huh?
Particularly to the deputy commissioner.
This direction? No.
One line of lordship, my lord.
No, I made it very clear.
That
the payment has to be made within 15 days from the date of the award.
Yes.
If there is a further delay in payment, they will be entitled for further interest, and this interest shall be taken from the salaries the state has to pay, which they can recover from the erring officials. All three of them.
Everybody has to follow.
Then things move in a very fast direction.
No, absolutely, but
Otherwise, it won't. The 2014 matter goes. Because if I start the other, this will take some time.
Lordship.
Then you people have to keep on waiting.
Yes, Lordship. Lordship, we call the item. I'll call P. Gugoi.
There's nothing else. Only to know as to whether you are going for a fresh tender or not.
Lordship, may give me some time. I'll just obtain the instruction. Some time, Lord.
If 6 to 9.
I know 6 to 9.
April hit the Yes.
My lord, I've got the written.
What is it? You're going for a fresh tender?
My lord. Just for 2 years, my lord. 2 years is about to complete, my lord, by 1 month.
Heard, Mr.
K. Chaudhary.
K. Chaudhary, the learned counsel appearing on behalf of the petitioner. Mr. Everything was there. Mr. B. Gugoi appears on behalf of the respondent numbers 1 to 4. You are appearing for Mr. Mr. Das for
For the private respondent.
all?
Yes.
5 to
5 to 11.
5 to 11. In all the matters they are.
Yes,
I am
yes,
appearing
all
in
the
three of the. I'm appearing in 3 of the matter. One matter.
In item number 7, Mr. A.
You are appearing in which petition?
4350. That is item number 6, 8, and 9.
6, 8, and 9 or his number to DD.
4351.
Mr. K. Chaudhary appears for item number A, petitioner so and so, and so and so, and Mr.
Mr. A. Just in item number 7.
Your name?
Is Mr. A.
So and so appears for petitioner in so and so.
Item number 7.
Mr. B. Gugoi appears on behalf of the Health and Family Welfare Department.
Yes, sir.
And Mr. D. Das, the learned senior counsel, assisted by R. Sharma, appears on behalf of some of the private respondents.
R5 to R18 in all the 3 matters.
All the private respondents. The instant writ petition were filed challenging the decision of the technical committee dated 12/8/2021 in connection with e-tender number HSBP /DIET/2021/113 dated 27/2021, and the decision of the tender committee and the decision for rejection of the tender communicated to the petitioners in the 3-4 writ petitions. it appears on record that on 3/9/2021, when the matter was listed, this court directed where all the files together, same orders were passed.
Same minute of the technical.
All same, na?
Yes.
There is an order of 3/9 in every case. On 3/9/2021, when the matters were listed, all the 4 petitions were listed. This court, taking into account the stand which has been taken and the request made by the Standing Counsel for the Health Department, directed the matter to be listed for motion on 10/9/2021, and till the next date, the financial bid in respect to the aforesaid e-tenders dated 27/2021 shall not be opened. It further appears that on 10/9/2021, when the matter was listed, this court directed for filing of affidavit by the Director of Health Service by 15/9/2021. And the petitioner was directed to file their reply by 20/9/2021. And accordingly, directed the matter to be listed on 23/9/2021. Until that date, the interim order passed on 3/9/2021 was directed to be continued. It further appears that on 23/9/2021, this court further directed the Director of Health Service to place the relevant records in original pertaining to the issues involved in the petitions, and directed the petitions to be listed again on 5/10/2021. Until then, that is 5/10/2021, the interim order passed earlier on 3/9/2021 shall remain in force. It appears that on 6/10/2021, the writ petitions were heard and was fixed on 28/10/2021 for necessary orders. However, thereafter, there has been no orders passed by this court, and the matters have been listed today. The Learned Counsel, appearing on behalf of the Family and Health and Family Welfare Department, submitted Where will I get the date
Lordship will find that page 24
of
of the WPC, my lord, 4350.
24? Yes, where?
Clause number 4 with validity for 2 years.
Where? Technical bit.
No, yes, below technical bit,
bid
thereafter
validity.
eligibility bid validity. Clause 4.
Page 22.
The learned counsel appearing on behalf of the petition, Health and Family Welfare Department submit
For 2 years.
that as per clause 1 of the tender document, it has been mentioned that the said tender was issued for patient diet services, which includes providing all raw materials like groceries, spices, fresh vegetables, egg, milk, LPG cooking gas, firewood, etc. for the preparation of food. He further referring to clause 1 submitted, that the diets which were to be served, which were to be supplied by the tenderers were for a period of 2 years from the date of commencement of the award. The learned counsel further submitted by drawing reference to clause 4, which stipulates that all rates shall be valid for a period of 2 years from the date of finalization of the tender. And the period of the contract can be extended for a further period at the discretion of the competent authority to a maximum period of a year. The learned counsel, therefore, for the Health and Family Welfare Department further submitted that taking into account that the bid validity was for a period of 2 years and only 1.5 months is left, the Director of Health Service has issued an instruction to him on 30/5/2023, intimating that the Directorate proposes to issue a fresh tender after cancelling the said tender, as it is almost 2 years from the date of the issue of the tender. The said instruction is quoted here in below. And look. In that view of the matter, as the respondent authorities proposes to cancel the earlier tender, which was the subject and wherein the rejection of the petitioners on technical bid was the subject matter of dispute. Nothing survives in the instant petitions. This court, in view of the specific instructions so received as quoted herein above, directs the authorities, grants the liberty to the authorities to go ahead with the fresh tender above the petitions.
Pending item 2 and 3.
Titan.
Yes.
There's only one apology, my lord. In the first half, I said that the draw of lots, the lottery is conducted by hand. Actually, that was the earlier process. Now it is computer.
It's computerized. Now it makes sense.
Now your lordship would kindly come to page. This is the October 2017 guidelines.
When was the notice issued? The paper publication?
Paper publication is on 12/6/2018. So this October
So
17
this
guidelines-
will hold the feet.
Yes.
Okay. Then
page 32, madam.
Yes.
This is the process of selection, clause 10.4.2. One application per applicant for a location. Applicant should submit only one application for one location. In case more than one application is received from an individual, all the applications would be clubbed together and treated as one application. In such cases, application fees received against all the other applications would be forfeited. Now, he submitted his application, Santosh Paul, SANTOS, Santosh Paul, PAUL, and Santosh Paul, SONTOSH, POL. That's why, madam, I have annexed both of the applications. In fact,
where?
At my affidavit.
Why there are two repetitions?
Earlier, my lord, I have approached, I could not get the intent, my lord. That impugn order, I could not get, my lord.
Which one?
You're getting.
5787.
Yeah, exactly.
That is challenging.
Challenging appointment of her, my lord. As distributor.
This is only for getting the impugn order.
After getting the impugn order, we filed fetch cause.
So you filed 8669.
Exactly.
Earlier was only filed for getting the impugn order.
Getting the exactly impugn order.
Set aside. This is set aside and quash the list stated applicant so and so foul eligible of so and so being violation. So why these are two?
My lord, that was that I could not enclose, my lord.
The LOI was challenged in the letter.
Letter of intent, my lord.
LOI was challenged in the letter repetition. That is,
Both are same otherwise. Only the LOI has been brought.
Exactly.
Now let us see this one.
Ranjit Borgo, affidavit by Ranjit Borgohai, IOCL.
Affidavit filed by
Ranjit Borgo.
Ranjit Borgohai on 2nd of January 2020.
Yes.
Yes.
My lord would kindly come to page 6 and tally it with page 9.
Page 6.
Dayal Chandra Paul, in the very middle, my lord, name.
Dayal Chandra Paul,
Yes, 3.8. Dayal Chandra
Santosh Paul.
Santosh Paul.
Hmm.
Then page 9, your lordship will see. Again, same application. Dayal Chandra Paul, Santosh Pal.
When it was submitted?
My lord, before the time period.
No. Why was it submitted twice?
My lord, the
There
applicant
should be a date out there on a declaration. There is no date. Yes, 13/7/2018, 23/6/2018. Did it? Page 62 and page 65.
Yes.
The first one is of 23/6/2018 and 13/7/2018.
Yes.
Okay, where is the advertisement?
Advertisement is in my records.
Wait.
It's in vernacular. The only explanation is in one application, he didn't specify his land detail. And in the another one, he specified his land detail.
Okay. This
So-
is LPG Bitor. Yes, can you read this advertisement? Here at Ligas clause number 1, very difficult to read. Photocopy. Now, how does he get hold of these guidelines?
But the guidelines are available online, my lord, on the website.
Hmm?
Guidelines are available in the website.
No, is it mentioned out there in your advertisement that you are to fill up as per the guidelines?
My lord, in the system, along with the application, the general instructions are also provided.
Okay, so in the general instruction, is it mentioned?
It is mentioned how to fill up. Now he missed the land details. So he again submitted along with his land details. For natural justice, my lord, once we rejected his candidature as per the first draw clause, the second one we accepted it of that application where his land details are mentioned. But again in the draw, he was not selected, the private.
So, is it required to give the land details in the first application?
Yes. In the application, the land details are required because later on, when we tally the documents, the field verification is carried out. Those documents are tallied along with the details provided in the application.
Now, so the first application is of no use.
Yes.
Because he has not given.
Yes.
But both the applications were filed prior to
Yes, a priority list was made.
prior to the first lot.
Yes, the inter se priority list was made. That is also available in the very next page of my affidavit. There also in the inter se priority list, the first list is of the candidates who belong to the Gram Panchayat. That is given the top priority. In that list, his name figured twice. So he had an added advantage in the first draw. The
His
moment
name figured twice.
twice because his father's name showed differently and the system captured him as two different candidates.
Where is it you have mentioned?
My lordship will see the inter se priority list at page 14 of my affidavit.
40?
1-4, my lord, of my affidavit. Number 1.
Name is same, my lord. Father's name is same. Only, my lord, instead of Pal, U is missing. It with PAL.
Even
Yes, where?
Number 1, Dayal Chandra Paul, Santosh Paul. Then again, number 4, Dayal Chandra Paul, Santosh Pal. So the system captured him as.
So you say that in view of two applications being filed, he was getting an added advantage.
Yes.
And as such, you had to cancel it.
Yes.
That's your side.
Then we clubbed both of his applications together, and we took the one where his land details are mentioned, and we allowed him to participate in the second.
Now, who got it? Nipen Roy?
My lord, Deepti Das 13. 1-3, my lord, Deepti Das.
But she's not there in the priority list too.
My lord, no, my lord. Once the first draw is cancelled, then from the remaining candidates, Again, another draw is conducted till the entire list is exhausted.
But where is the draw? This is the first draw.
Yes.
Where the petitioner was there at serial number 1 and 4.
Yes.
Where is the second draw?
That is available at page, my lord. At page 43 of the read petition. This is the attendance sheet. Page 43 of the read petition. And the inter-sale list is also there at page 34.
This is the second row?
Yes, second redraw, man. Attendance sheet of qualified applicants present at the redraw of selection of LPG district.
Okay. So you gave the precedence as regard the second application, no? As could be seen here.
Yes. Yes.
Now he participated in the second row.
Yes. We allowed him.
You allowed him, but he participated.
Yes. He
Without objection.
Yes. Without objection. Yes, my lord. That rejection letter was provided to him. He signed it. It's there. I have annexed it also. And he never challenged that.
Then.
Yes.
And he participated.
He participated.
Okay. Then.
Then my lord, Dipti Das was selected. Serial number 12.
What is this at page 44? Oh, these are all attendants.
Yes, my lord. My lord, see page 34. That is the same priority list of the redraw. 34.
This is priority list, second row.
Yes. Yes.
No, it can't be.
Yes.
Oh, yes. Okay, priority list, Santosh Paul. Is it the same one you are showing? No.
Yes, the same one as page 43. 43 is the attendance sheet. 34 is the priority
No,
list of
isn't this the
redraw.
same document
No,
which you have shown it out here in your affidavit? This one at page.
In my affidavit, that is the first draw. This is the redraw. At the
How do
very,
you say the date?
my lord, at the very top, the redraw is written, my lord, at page 34 of the read petition. Redraw is given.
Where?
List of applicants found eligible for redraw for selection.
Redraw. Redraw. And there, the petitioner's name is number 1?
Number 1.
Then why the petitioner didn't get it?
No, my lord, the entire lottery will be conducted from among these 14 candidates.
Okay. Then how did the petitioner get it? They got it?
Lucky draw, my lord, computer's lucky draw.
And where is it mentioned? The computerized happened?
My lord, the result as per the guidelines, we inform We declare it in the room itself,
Hmm.
and we inform the selected candidate by a mail, by an email sent to the registered email ID.
So you say it was because of the petitioner you had to have the second draw.
Yes.
Is there any orders for cancelling the first draw?
My lord, we cancel his
When
selection.
was the redraw held?
My lord, redraw was held on. Just November 2008.
But in the redraw, why did you take his petitioner's application, which was the incorrect application?
I've given.
Kindly come to page 34.
Yes.
Okay.
Yes, number.
Now
the
see, the
number.
petitioner's name is against this IOC, the application number 20, the last is 23/6/2018.
Yes.
23/6/2018 is the first application. And the second application is on 13/7. If you kindly see your thing, which is there, the first one at running page 68, is annexure P4.
Yes.
There were two applications. One is of 23/6/2018 and the other is of 13/7/2018.
Yes.
Now you say that you had taken not taken the first one, but you have taken the second one. How is it possible? And if you see his enclosure, your affidavit, the two applications, the first application is at page
Yes, ma'am.
P1, Kohli, out there, which does not call the land details.
The rejection letter, my lord. Rejection letter will explain, my lord.
Huh?
Page 13 of the affidavit. His rejection letter. Page 13 of the affidavit.
Which affidavit?
The one, the IOCL one.
IOCL doesn't have a page 13.
151.
The problem is now that we don't have these details.
running
It is being cut out. Why haven't you taken it? Annexure?
Annexure P3.
P3. This was given when?
My lord, after his rejection.
First rejection or second rejection?
First rejection. Second
Please
rejection.
refer to your application dated so and so for award of so and so. We are like to mention here that your name as per the application appearing of Iman, son of so and so with application of list of heirs, serial number Iman. This happened because you have changed the spelling of your father's name and serial number 4 as Santosh Paul, which the system could not detect, and your name appeared twice in the name of the eligible Iman application and got the job. As per the guidelines, the name of the address considered only once at the time of job. Since your selection in the area as so and so is rejected and redraw will be conducted. Now this was done on
22nd.
whose signature is down there?
My lord, that is the DGM LPGS and the petitioner's.
So on 24/10/2018, he has signed this.
And the redraw was held on, as per my affidavit, the statement given in my affidavit, my lord, 5/11/2018.
5/11/2008. 18.
Yeah.
And when he has there, it is there, page 43. So his second application was rejected. So the first application remained.
Then with the correct name of his father.
Okay. So not on the details of his use as what you have said that the first application did not contain that.
That is his contention in the writ petition. That two was submitted because in one I missed the land details.
Okay, anyway. So on 5/11, after this receipt, he had participated.
He participated.
So then
Dipti Das was selected, my lord, the private.
so we are on this. Now Dipti Das. Now what happens? As per the petitioner, she should be in the priority list too, isn't it, madam? As per you, the Dipti Das should be in priority list too.
Because she is not entitled if the documents are, my lord, scrutinized, because she is not a resident, her Aadhaar card, everything, my lord, NRC, she is not a voter of that area, not even that constitutes.
No, if she is not, she will be there. If we see the
Her case, how can it be considered?
No, it can be considered. It is not that it can't be considered. Now let us see this particular rule 5.
If not available, my lord.
No.
one is
That
not
particular
available.
you have referred to now 5. Where is it?
Yes, my lord.
Where is that particular thing? As per this,
70, yes, my lord.
this priority is
I
given
will
where,
also-
Mr. Counsel? Where is the priority?
Yes, sir. I'm ready. Yes, page 22 of the repetition.
No, that is an old one.
No, my lord. 17 is, my lord, that is going on.
No, that is June. We are concerned with October. Your voice has gone.
Page 35, my lord,
Of
the guideline.
okay, 35.
The draw of lots.
Draw of law.
Now, 11.5.
I have not been
My
given
lord,
a copy.
my lord, then the priority, it speaks about priority list with regard to widows and dependents of armed forces. Then 11.6 on the very next page.
Okay.
Interest-
Eligible residing in the concerned Gram Panchayat of the advertised location. Madam, you have got this copy?
No, my lord, I don't have that.
You have not made an extra copy for her? Give it to her. You can do. Okay. Now, as per list 3,
My lord, 11.6.
11.6.
11.6.
eligible
it's written
applicants
this one.
residing in the concerned Gram Panchayat of the advertised location.
Exactly.
You say that she is not.
Not.
Okay. Eligible applicants residing in the concerned revenue subdivision of the advertised
That is
location.
also not.
She is not. But these 3 she will come. Eligible applicants not residing in the concerned Gram Panchayat or in the Iman of the advertised location. She will come under 3.
She also not.
Why?
But because she is not, my lord, residing either in revenue subdivision or my
That
lord,
is why.
advertised location also she not. Advertised Jamla is somewhere different, Mirza is somewhere different.
That is why she won't come in. She is not advertised. Here it says not residing in concern or in concern of the advertised. That means she is not. She
Or
does not
in
come under
the
1 and
concerned
2.
revenue subdivision of the advertised location. Eligible applicants not residing in the concerned Gram Panchayat or in the concerned
So
revenue
she
subdivision of
she
the.
does not fall under 1 and 2. Anybody who does not fall is list 3. Now your case is that she has been put in priority list 1.
Yes,
And as such, this is the fault which have done.
ignored it. Yes. Ignoring the guideline.
So
So
she
if
could not
persons are
have.
available, if
Okay.
persons are available, then my lord, they should be given priority. If persons from 1 and 2 is not available, then it will go to 3.
Now, were you number 2 in the list? There is no draw. The draw is only 1. So you say that the second draw is bad.
Redraw.
Huh?
In redraw, my lord, my document shows, my lord, that in redraw he is first. The redraw also, his name is appear in the first thing. The redraw is page 34. Page 4. It is redraw, my lord.
No, they
Yes,
cannot be
eligible for
redraw. Only one person only comes. There cannot be many person about it.
Headline, my lord, page 34. List of applicants found eligible for redraw.
These are eligible for redraw. So these are
for
all the
redraw for
persons who
selection
are
or
put in the priority list 1, priority
So,
list
my
2.
lord, his name was considered for.
So
redraw
you,
also.
it is not sure that you will come, you will be eligible,
That is not sure, man. Yes, but his name
but
is.
he cannot get it.
He can't.
That is your case.
No, my lord, I should be given because, my lord, that list of applicants found eligible for redraw. For redraw, I was eligible. And my lord,
No, they
I'm
not
fulfilling the
you.
criteria.
No,
Others
madam,
also
not
there.
only you.
Others also
Apart
there.
from respondent number 4, there are other 13
Others,
people
yes, so many times, so many persons are there.
eligible.
But why I should get it? Because, my lord, I feel all the criteria.
No, the others may also. It is a
Others-
question of draw of lots.
No, my lord, there are some difference, my lord. There are
Why?
lots. Because
There are many other persons who are there.
Santipur who filed complaints is from Santipur. Guwahati Santipur.
Who?
One lady, my lord, here. So, my lord, she cannot be competent. Because she resides
All
here.
these other persons who are there, you say that respondent number 4 is not eligible, well and fine, because she does not meet all these criteria. And as such, she should be in the priority list 3, not in priority list 1.
Yes.
Let's admit that. But then also the other people who are there,
Yes.
they are otherwise eligible. You have not pointed out that others are not eligible.
Also, my lord, record also whether they are eligible or not, any other participant. Because, my lord, my land and everything.
But
I
you have not
fulfill the
challenged that
criteria.
the priority, the other people should not come on the priority list 1.
No, my lord, that I have not challenged.
Then
Because I fulfill the criteria. Number one.
absolutely, you fulfill
My
along
lord,
with you other 13 also.
Other 13, I don't know about them, my lord, because the.
So if you don't know, so how can you
record will-
challenge?
Record will say, they have not come to the
This
court, my
court
lord.
is
for
not
relief.
going to look into
And my
that.
lord, because if my lord, her cancellation is there, but I'm not getting it. because
Okay,
I've
so
come to
now we are
justice,
concerned with
things same remain.
whether the petitioner respondent number 4 is a resident of within the same locality as per eligible. Can the respondent number 4 come within the ambit of priority list 1?
Gram Panchayat.
Yeah. Now let us see your decision on that, where you have stated that she comes within it. Why have you decided that she, because there is a specific allegation that she does not come with it.
My lord, once the candidate is selected in the draw, we ask for a security deposit. It is deposited, then we go for the field verification of the credential. Now, during the field verification, that it's not the committee is not going into the field and seeing whether she resides there or not. What the committee's job is to write to the competent authority and ask for an opinion. Now, the document which Dipti Das, the private respondent, submitted along with her application regarding residence is the standard residence certificate at annexure P5, page 15 of my affidavit.
Just 1 minute. What are the documents on the basis of which you say? You say to be seen for the purpose of residence.
Yes, yes. This is the standard residence certificate submitted by her along with her
No.
application.
No. As per the guidelines, is it mentioned out there?
No.
What is your basis to say that this person resides out there?
My lord, the eligibility criteria first thing say that you have to be a citizen of India and a resident of the advertised location. Resident, my lord, not permanent. It says only resident. So the documents are not specified. In the guidelines, the documents are not specified. So what kind of documents you have to submit? Now she submitted a standard residence certificate issued by the Tehsildar circle officer, and that certificate said that she is a resident of village Jamlai under 42 number Jamlai Kalyanpur Gram Panchayat. Then we issue a letter to the concerned circle officer, asking for 2 queries.
Where?
Page 15 of my affidavit, annexure P5.
It is good. Yes, P5.
Is
Standard, this is a standard residence certificate.
Yes.
Okay. Then
Village Jamlai 42, Jamlai, Kalyanpur Gram Panchayat. Then the very next page, my lord, we issue a letter to the concerned circle officer asking for 2 queries.
whether so and so the selected candidate for is a resident of village so and so, whether 42 number of so and so are the same DP.
Yeah, because the advertisement said Jamlai Kalyanpur. And here the standard residence certificate says 42 number Jamlai Kalyanpur Gram Panchayat. And in the reply, the circle officer says on the very next page,
Is a lease resident
yes,
in the house of so and so. In this regard, an official inquiry has been conducted and the Gaon Pura headman Lot Mondal found that he is residing in the house of Abu Jafar, village so and so as a lease resident since 4/7/2018. However, she is not a permanent resident of the locality and is living only since 4/7 only on a lease basis at village Jamlai. No voters list NRC were found to establish her as a permanent resident. Of your letter is that 42 so and so is the same. So she is not otherwise a permanent resident.
permanent resident. But the guideline says resident.
When was the advertisement?
I'm sorry.
When was the advertisement issued?
Advertisement was issued on 12th of June 2018.
And she resided there from 4/7/2018?
Yes. Residing.
No, after the advertisement.
My lord, the criteria is always that you should fulfill all the norms as on the last date of submission of application.
No, not fulfill all your norms. But
last date
anybody can, after the advertisement, looking into the advertisement, can very well stay at a, take a residence out there. Would it be entitled for the getting of that?
we have to go as per our policy guidelines.
No, your policy doesn't say anything to that effect because you see, your policy is for what? Why are you giving it to those persons, giving a priority? There's a basis. You couldn't have said that, okay, anybody can participate. Why are you saying that giving a basis for that? There has to be a basis. Anybody else can very well come up, enter into a lease agreement.
Our goal is to uplift the persons of that locality.
But she entered into the locality after 4/7/2018. Then under such circumstances, how can you bring her within the ambit of list 1? I would have understood she was earlier residing. But she started residing only after the advertisement. Then
Silent on the permanent part.
no, not only forget about a permanent, a person may be residing. Maybe residing out there, may not be permanent. But she only started residing from 4/7. The notification was issued on, advertisement was issued on 12/6. And on that very day, and kindly appreciate one thing. She started residing on 4/7, submitted her application on 13/7. Now, can you give the benefit for that? Would that be a construed to be within the meaning of that giving a benefit? Because your idea is to uplift the people. Then how can you say, in more particularly when this particular document makes it so clear that she has nothing, she only started from 4/7.
Again, my lord, I know I'm repeating, my lord, but resident.
Understood. No, but can it be your residence? Let us assume you are giving it for priorities. Would it be of any sense that just 7 days or 9 days before she enters out there, enters into an agreement, and thereafter
She becomes eligible for the priority.
she applies and gets it, she becomes a priority one, whereas the person who have been residing out there You are equating both together. Can it be done? Would that be the basic intention behind your thing? And if that is so, then it is a very serious thing. You should relook in your guideline. But it has been made clear that only on 4/7, just 7 days before that she has entered, 9 days before. And she filed it on 13/7.
Guidelines are valid.
So the first part, there are three. 11.6 says about three things. The first is whether she is a resident of Gram Panchayat. If she is a resident of Gram Panchayat out there, very well. This Gram Panchayat thing is here. And the second part is as regards
Revenue.
village.
Revenue.
A person who could have been in the revenue village, you are not giving her the year. Or the number two, a person who is residing within the locality of a revenue village would not be entitled to, but the person who just enters into that particular document, and whether she has been residing thereafter or not, that also you will know.
Yes.
And she has been only there for 4 months. From 13/4/7, and the date on which it was done was 9/1. Yes, Mr. Khan, you come. That's your point.
I'd like to draw.
No.
These two documents, my lord.
Why are you drawing? This isn't. Am I not taking up your case properly?
Your lordship is taking. I want to place two documents.
Yes.
My lord, lease agreement, agreement for lease. There it is only land. There is no house. Land agreement, my lord, he has filed. For respondent for repeat for respondent 4, my lord, page 11. And the land agreement, agreement for lease. There are only land stamps, no house to stay. And my lord, in the second page, page 12, that the lessee is allowed to construct, go down, and showroom over the said plot of land. It is only land, no house. House is residing. Page 12, paragraph 1.
Where?
Is affidavit, my lord, I don't have the serial number, but
Oh, this one. Deed of lease.
Yes, lease deed.
Is
Agreement
the
for lease.
absolute owner and possessor of a plot of land measuring 4 kathas covered by so and so in the district of Iman. Where is the lessee about desiring of obtaining therefore in term lease basis for their
Paragraph one.
proposed setting up of a godown for LPG are subject to compliance of all formalities.
So I'm reading, my lord, that the lessee is allowed to construct.
So
go
this
down
is
and
entered on 12/7/2018.
It is not registered.
1 day before it is registered.
Yes, 1 day before it is registered. And there, my lord, the first clause is, my lord, that the lessee is allowed to construct, go down and showroom over the said plot of land. So there is no house to stay. House is residing without house. Simple plot of land. So she is not resident at. From her affidavit itself, it proves that, my lord, she has taken lease of the land which belong, my lord, in the field, paddy field. And the residents of the area also have given an application. That also I have put it. Your lordship got it, but another application. In the affidavit reply, I filed on my lord 29th of January, 21.
Why is this judgment of Justice Rishikesh Roy here? Any idea? Who has enclosed? Nothing. In WPC number 5111/2012.
Don't know, my lord. The application filed, my lord, by 142 residents of the area. Buddha, my lord, General Manager LPC, I would like to place that file.
Where?
It is in my affidavit, my lord,
Oh,
filed
that
on
one.
29 January, page 14. They are given in Assamese. I have translated copy, my lord.
3/2/2020.
Yes, my,
Assamese one.
yes. Here, my lord,
We resident of
142 villagers
Choyancho
and
know from relevant that Ria is a located man, but Indra is not a resident of Yaship. Permanently resides in Mirza and the least is submitted by West maintained by complete report. Yes, Mr. Council, where did you reside?
My Lord Lordship, I am a tenant of the particular area and there is no tenancy, my Lord, agreement. But so far, my Lord, as per required land requirement, therefore we enter into lease agreement.
No, that is okay, but where did you reside?
But prior to that, I am residing here as a tenant.
When?
But there is no any such document.
No, where did you reside?
But there is not specifically mentioned how much month or how much year.
No, no, in which part you are saying where you have stated that you have been a resident there?
Shiva, I have narrated here
Mirza Town.
my affidavit in opposition,
Mirza
page,
Town, my lord.
page 2, my Lord.
Of your affidavit?
Yes, Lordship. Page 2, my Lord, paragraph 6, my Lord, I have written that the deponent submits that to be a LPG distributor of IOC, permanent resident of the concerned Gaon Panchayat is not a mandatory requirement. And how many years she
Just 1 minute, just 1 minute.
in the said Gram Panchayat.
First of all, you don't have your, you have not, yes, Dipti, no, Dayal Kumar Paul. Yes, it is enough. Wait. Dayal Kumar Paul. Ah, got it. Yes. Page?
Page 2, my Lord.
Ah.
There are 6, my Lord.
There are 6.
The
Yes.
deponent submits that to be a LPG distributor of IOC, permanent resident of the concerned Gaon Panchayat is not a mandatory requirement. And how many years she has been residing in the said Gram Panchayat is also not a condition precedent. Thereby the contention made by the petitioner is baseless and not sustainable. And so far my agreement, when I enter into lease agreement, I have narrated, Lordship, that on 4/7/2018, the deponent entered into a lease agreement with landlord Abdul Jabbar, and he is residing at the residence of Abdul Jabbar.
Where is the lease agreement?
Lease agreement, my Lord, I have enclosed, my Lord. That is page 11, my Lord. Page 11. On 4th day of July, 2018, they enter in
Page 11.
Page 11 in my number. Now new number also answered, my Lord.
Page 8. Agreement for lease.
Yes. And it was executed on 4th day of July. And for this purpose, Lordship, because of necessary for this go down. And here, my Lord, page 12, it is clearly shown that it is second party is entitled to lease out the said accommodation. So accommodation also over the residence. And the condition, my Lord, number 1, that the lessee is allowed to construct, but that not specifically mentioned whether construct any my room or and go down and showroom over the said plot of land. And now, my lord, thereafter,
But Mr. Counsel, where is the lessor first party is the owner of the land measuring 0 biga 4 kathas covered by so and so in the district of Kamrup, more specifically described in the schedule below, and is entitled to lease out the said accommodation in favor. There is no house. It's only the land. You see the schedule? It's only the land. Where's the house? And there is a direction to construct. Where are you residing?
this is for, my lord, go down for the purpose of this.
Absolutely. But
And-
where is
and-
the house?
And I am residing at the residence of this.
Where is it?
Owner.
Where have you mentioned?
But the report, as per inquiry report also submitted. my lord.
Forget about the inquiry report.
That is, I am
But the
residing
fact
as a
is,
tenant.
have they mentioned anything to that effect? You have not mentioned. Anyway, we'll do one thing. We'll post it on some other day when you get me one instruction. And madam, you find out that particular aspect. You see, there are many judgments on the question on section 1026. You see what happens? 1026 is a provision whereby a person who is a scheduled tribe is exempted from the purpose of getting payment of income tax. But while payment of income tax is exempted, that particular tribe has to be a resident of a particular state where it is being recognized or area where it is recognized. Just for example, I'm giving you an example. There was a case, I forgot, ERPL, some employees and all. These people were scheduled tribes. Now, if they were a resident of this side, you must have been to Bongaigaon.
Yes, sir.
On this side of the road, they come within the 6th schedule. But if they stay on the other side, they are not, they don't get the benefit. They have to pay income tax.
Here also Khanapara, one side is Assam, another side is Meghalaya.
But out there, one side is Bongaigaon, the other side is Baksa. So if they say in Baksa, they are entitled to because it falls within the 6th schedule. But if they are on the Bongaigaon, they don't get the benefit. So you find out, and there, our division bench have also decided on this aspect. What does a resident mean? The resident has been specifically mentioned out there, and you may find out that a mere passerby would not be a resident. He has to be there for some time.
It's a vacant land.
Ah.
Agreement is made, my lord, after advertisement. That too is a vacant land.
Ah.
So house he can be resident.
Then
Now
hope-
they came and, my lord.
I hope Mr. Bhardas gets the.
Regarding the resident part, I'll see into this judgment matter. But what my learned friend is suggesting is that is regarding the showroom and the godown.
Understood, but where is she is a
For
resident?
showroom and godown, you can take a vacant land for lease. For
I'm not on that, but is that a consideration for giving the priority?
No.
So we are not concerned with that.
Residence
We are
is
concerned with the question of resident.
That is completely different.
And you see, the circle officer's report is based upon 4.7. That is this particular document, which doesn't have a house. So you have to test the circle officer's report on the basis thereof. You can't have it on the in thin air.
And this is one of the documents, my lord, the circle officer has sent to the, my lord, senior, additional senior government advocate. Here also he has stated, my lord, circle officer, that no evidential document has been traced out of Timothy Das.
No.
For
Have you
this
brought?
NRC,
No, madam. Have you brought on record that document?
additional senior government has, my lord, submitted for the court. It should be on the file.
Not necessary. Madam, you do one thing. You file a short affidavit on this document, saying that the additional senior government had also produced during the a copy was given to you. Madam, you understand? If you do it, then only this court can
Yes, my
put
lord,
it
that
out
will be
there.
part
na?
of the record.
Yeah.
Otherwise, CS does pass the. to the court.
Heard Miss and Mrs. N. Soikia, the learned counsel, appearing on behalf of the petitioner. Mr. P. Bhardwaj appears on behalf of the Indian Oil Corporation, and Mr. K. Bhuya appears for the respondent number 4, and Mr. N. Goswami appears for
5 and 6.
respondent number 5 and 6. The matter has been heard at length. The issue primarily in the instant repetition arises as regards the interpretation of clause 11.6 of the Unified Guidelines for Selection of LPG Distributorship pertaining to the period October 2017. 11.6, clause 11.6 stipulates that there shall be priority given on the basis of list persons, eligible persons, applicants in the list 1, list 2, and list 3. In list 1, it has been mentioned that eligible applicants residing in a concerned Gram Panchayat of the advertised location would have a preference over eligible applicants residing in the concerned revenue subdivisions of the advertised locations who are in list 2. And those in the list 2 shall have a preference over eligible applicants who are not residing in concerned Gram Panchayat or the concerned revenue subdivision of the advertised locations. During the course of the hearing, it transpires that the respondent number 4 and the petitioner herein were brought within, along with 12 others, were brought within the fold of list 1, that is residing in the concerned Gram Panchayat of the advertised location. On the basis of the draw of lots, the petitioner, the respondent number 4, was awarded the contract, awarded the LPG distributorship. It is, however, relevant to take note of from the perusal of the documents that the respondent number 4 filed her application on 13/7/2018 in pursuance to an advertisement dated 12/6/2018. It further appears that the applicant's claims, the respondent number 4 claims to be resident on the basis of an agreement of lease of a land dated 4th of July 2018, whereby there is a authority given to the respondent number 4 by the landowner to construct godown and showroom over the said plot of land. The said document under no circumstances show, a perusal of the said document do not show that the agreement for lease was for a particular, for a rented accommodation. It further transpires that subsequent thereto, this very plot of land, in respect to the very plot of land, there was a registered document, registered deed of lease entered into on 12/7/2018. And thereupon, on 13/7/2018, the applicant, the respondent number 4, submitted her application. The guidelines at clause 11.6 says about resident. This court is of the opinion that the respondent IOCL who have issued that guidelines should make it clear, should also place before this court as to why clause 11.6 was incorporated in the guidelines. Under such circumstances, let the respondent IOCL file an affidavit within 7 days. Within 7 days. Mrs. Ensegier, the learned counsel appearing on behalf of the petitioner, submitted that during the course of the instant proceedings, the circle officer had issued a communication dated
Is it 9 December 21?
9th of December 2021, which throws light on the inquiry so made by the circle officer pursuant to circle officer on Nine 1/2019, Annexure P7 to the affidavit filed by the respondent IOCL. Liberty is given to the petitioner to bring on record the said document by filing an additional affidavit, which shall also be filed within 7 days from today. Taking into account that the matter has been heard at length, let this matter be again listed on 6th, on 13th of June. And shown as part heard.
May I suggest, my lord? If he produces the PAN card or my lord Aadhaar card, that will also show her address.
No, it's okay, but yeah.
Because
And,
to identify the person, government has found this device, PAN card and Aadhaar card.
No, madam, you just get hold of that judgment, you will get.
Yes.
I've given it to you. You'll get that idea of that. What is a resident meaning? Who is a permanent
Which
resident?
are your procedure? I have not done for. On Manmohan Singh resident, that was delivered by Honorable Justice M. Sharma, that I have done.
But this is more
which year,
particular. What is a resident? There also the Income
which
Tax Act does not show who is a resident. It doesn't say permanent resident. And then it says that a person who just comes in.
Judgment of which year? Procedure, remember?
I think that is by Justice Biswas and Justice P.G. Agarwal there, maybe. But it starts with BRPL Employees Association.
I apologize for the inconvenience, madam. May I please mention item 48, 49, and 51? Slight urgency in the matter. Matter pertains to employees of the Escart Bank as well as retired employees. They have not been given salaries and their retirement benefits since the year 2000.
Salaries and retirement benefits since
The year 2000.
which corporation?
Escart Bank. Assam State Cooperative.
Escart Bank is the problem. Chalo, we'll have it on when?
Whenever convenient.
Convenience is very difficult nowadays, Mr. Counsel.
Yeah.
20 June. If you want it, I can fix it on 8. You want it? But I am not there.
20th then, madam. May I also pay for
20th.
liberty to
Huh?
mention the matter for updating?
Yeah, 20 is the matter on 20. I take it. Heard Mr. So-and-so, the learned counsel for the petitioner, who submits that taking into account that the petitioners herein have not been paid their salary and their entitlement since
the year 2000.
2000?
2000.
Two.
From 2000.
From 2000, year 2000. And as such, the petitioners have been suffering a lot, taking into account the same. This court fixes the matter on 26/2026/23 and further gives the liberty to the petitioner to mention the matter for upgrading.
Deeply obliged.